Anybody to order item number 1?
Please.
For reasons mentioned in the order, the prayer for bail of petitioner number 1, Muhammad Ziaul Hassan, is rejected. However, the petitioner number 2, Muhammad Arshad Ali, is allowed to go on bail of rupees 50,000 with one surety of like amount and certain conditions.
Highly obliged. Obliged.
For listing on Monday,
Monday listing is not possible.
Monday,
Not Monday. Date sheet. Monday when have you filed?
total.
It will come. It will come as per its due course, because next week, whole week will be likely to be motion week. So it will come up in its own course. Monday we are not allowing. It will come. Tuesday it will otherwise also come. No need of mentioning.
Another, we have item number 20.
20.
After basic ownership, the respondent by the petitioner is present. Interim is there.
Now, why are you praying for adjournment? The reason for seeking adjournment.
On behalf of this is some personal difficulty with S. Rana.
Personal, okay. Heard Mr. N. Ahmed submitting on behalf. You have informed the petitioners.
Yes, sure. Lordship, interim order may kindly continue.
Mr. N. Ahmed submitting on behalf of Mr. S. Rana, Learned Counsel for respondent number 2, who seeks for an adjournment on the ground of personal difficulty of the conducting counsel for the respondent number 2, respondent number 1. Learned Counsel for the petitioner raises no objection to the said prayer, hence the prayer is allowed. Let this matter be listed after vacation. The interim order shall continue till next date.
May I please, your Lordship? Lordship, I would like to mention item number 48 of the daily list, Lordship. In this matter, Lordship, we have filed an additional affidavit, Lordship, on yesterday, Lordship. That is not on record, Lordship. Lordship, may kindly fix it on Wednesday, Lordship. Directing the registry to bring the additional affidavit on record, Lordship.
Heard Mr.
N.K. Sharma, Lordship.
N.K. Sharma, Learned Counsel for the petitioner, who submits that the petitioner has filed an additional affidavit which is not available on record, hence prays for adjournment, and also prays for bringing the said additional affidavit on record. The prayer is allowed. Let this matter be listed on
26, Lordship.
26.
Lordship,
The
interim order
registry
is
is directed to place the additional affidavit filed by the petitioner along with the case record.
interim order may be
The
continued.
interim order shall continue till next day.
May I please, your Lordship? I beg to item number 61, Lordship. Orders matter in supplementary list, Lordship. I have filed an IA for modification of the order, condition of the bail order, Lordship. That may be taken up at 2 if possible.
So we will take it up
Before rising, Lordship.
before rising. We will take it.
Obliged.
Item number 55 of the basic. Is the order Mr. Lordship? Can you please to update their arguments with their question?
After hearing, after bail hearing.
The bed, yeah.
May it please, your Lordship. I beg to mention one criminal appeal, my lord. for listing. It was earlier listed and the password forwarded due to difficulty of CBI council, my lord.
Is it part heard?
No, my lord.
Then you
New
have,
meter, my lord.
no new matter, no mentioning before this court.
My lord, actually, but it was listed.
Hmm.
It was passed over.
You
my
have
lord,
to
on
pray
13th.
before registry, or there are senior courts are also.
Obligations.
I'd like to mention this matter for this bail application.
When have you filed?
My lord, it is the LCR you received. my lord. LCR bought for LCR received. Any date next.
Pending case.
Pending. Any date.
What matter?
NTPS.
Senior court. There are senior court taking NDPS method.
Lordship, I beg to mention item number 29 for little accommodation, Lordship.
Item number?
29, it may be taken up at 2 p.m.
2 p.m.
Yeah.
May be difficult. Why?
Lordship, in the forenoon session, I have a personal difficulty.
You would leave.
Lordship,
Okay.
at 2 p.m.
29 at 2 p.m.
Oh, Lordship.
I beg to mention item number 8, the daily motion matter on behalf of Mr. Alcorabo. And we will allow to withdraw this.
Withdraw.
Yes, sir.
Heard, Mr. What is your name?
Mr. D. Gogol, on behalf of Mr. Alcorabo.
D. Gogoi. Submitting on behalf of Mr. S. Bhattakur, learned counsel for the petitioner, and praise for allowing the petitioner to withdraw the instant criminal petition. Why are you with? What is the?
We have filed this petition for question of the FI. In the meantime, Sachin has been filed.
Okay. Considering the submissions made by learned counsel, the prayer is allowed. This criminal petition is dismissed on withdrawal.
May I please, Your Lordship? Lordship, I beg to mention item number 37, Your Lordship. Bail hearing matter, Your Lordship. CD has not arrived, Your Lordship. Maybe fixed after vacation, Your Lordship.
Heard, Mr.
P. Daimari, Your Lordship.
P. Doimari, learned counsel for the petitioner. Also heard Mr. R. Kaushik, learned additional public prosecutor, who submits that some more time is required for producing the case diary. The prayer is allowed. List this matter when 16 is Sunday.
17.
16, okay, okay. 16, list this matter before on 16 July.
Oblige, Your Lordship.
Yes, yes. New list. It will come up. When have you filed? June 25th, 24. What is the subject matter? No, what is the offense? Will it come before this court? Because there are senior courts. No, let registry decide. It will be listed as per. No mention memo. You are unable to say what offense is, because there are other senior court taking bail matters. You have to mention before senior court, or it will be otherwise listed on its own by Monday or Tuesday.
Yeah, please, Your Lordship, my lord. Lordship, I beg to mention for listing of a bail application, Lordship. Lordship, it was last listed on 12/6, and this honorable court was directed to file an additional affidavit. We have filed the additional affidavit, Lordship. It may be come on 26, Lordship. There is an urgency,
What is
Lordship.
the matter?
NDPS case, Lordship.
It is not part heard matter. You have to mention it before senior court. Senior courts are taking up NDPS matter. 30?
32, Lordship.
Have you informed the
Yes, Lordship.
heard Miss M. Deka, learned counsel for the DRI, who prays for an adjournment with the consent of learned counsel for the petitioner. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed after vacation.
May I please, your lordship, my lord? I beg to mention item 38 for upgradation, my lord, at 2 o'clock, my lord.
2 o'clock, we have already fixed.
And after that, my lord, 439 matter, my lord, he's a 23-year-old boy, my lord, possibly consenting, my lord, lordship is the FI, my lord.
No, we will take it up. Today it will reach 38.
38, my lord.
It will reach.
Obliged, my lord.
Yeah, please, lordship. I'm praying for listing of a bail application, madam, on Tuesday, madam.
What matter?
NDPS matter earlier rejected by this court, madam.
Earlier rejected by this court.
By this court, madam.
Okay.
May it please, your lordship, I'm praying for listing of a bail application on Monday, lordship. It was filed on yesterday, lordship.
What is the matter?
It's a cattle act, lordships.
But there are other courts, senior courts taking up.
Deeply.
If I reflect the mention of item number 27.
27, yes.
Can be taken up Monday or Tuesday.
Have you informed, heard Mr. R.R. Kaushik, learned additional public prosecutor, who prays for an adjournment with the consent of learned counsel for the petitioner? The prayer is allowed. Let this matter be listed on Tuesday on 25/6.
Okay, item 2.
May I please, your lordship? 439 application, my lord, allegation of committing offence under section 21B and 27 of NDPS Act, my lord. Arrested
21B,
on 6/6, my lord.
21B.
21B, my lord, it is not attracted, my lord. I'll try to satisfy your lordship. Kindly see page 15 is the FIR.
No, whether case diary would be required or not.
My lord, first, my lord, allegation is that he came to purchase, my lord, not recovered anything from him. Only from the prime accused, my lord, 5.51 gram heroin was seized, my lord, from the prime accused. Allegation is that these persons, my lord, 8 persons, they used to come to purchase from him, my lord. Nothing has been recovered from this petitioner, my lord.
When were you arrested?
Arrested on 6/6, my lord. My lordship will see page 15, my lord, for a moment.
Yes. Yes.
Page 15, my lord. The one drug peddler, namely Krishna Saikya, was arrested, my lord, and seized 5.51 gram heroin, my lord. Next paragraph, my lord, second paragraph. During apprehension of the drug peddler, it is known that the following persons were frequently made contact in the mobile phone of apprehending accused for purchasing drugs. While they came to purchase and consumption of drugs in the apprehending arrest peddler house, namely Krishna Saikya, alias Dhunu, at that point of time, the rider party also nabbed them. My lord, I am at serial number 8 down below, my lord. Montu Bora, my lord. Nothing has been recovered from this 8 persons, my lord. And in the next page, your lordship will find 5.51 gram heroin was seized from the possession of Krishna Saikya. My lord, from that view of matter, my lord, 21B, it will not attract in respect of the present petition. Address 27, my lord. 27, my lord, what it transpires, my lord, the punishment prescribed is only 6 months, my lord.
Why it was rejected by the special judge? Where is the rejection order?
No, rejection order, my lord, I have not annexed, my lord. It was not moved perhaps, my lord.
No. Yes, that.
In
6 months, it's 1 year.
yes, my lord. 6 months, no, my lord. In respect of specified
No,
contraband matter.
therefore, I want to know why it was rejected. If this was the plea before the special judge, why?
Perhaps that was not moved before the special judge, my lord. I'm not
Then you have
informed
to move before special judge.
I'm, my lord, exercising that power under 439.
No, but when 437 is available
My
to
lord,
you,
that is right, my lord. Yes, my lord.
then why this court should exercise power? When there is a hope that you could have got relief under section 437 also.
My lord,
Whether it was moved or not,
not from.
then you have to go before the trial court.
I think there is a judgment saying that 437 has to be.
Not.
No, I am not saying that it is mandatory.
Not mandatory. that,
If he is in custody, he can approach.
My lord,
But now, why should this court exercise its discretionary powers when he could have availed
approach
the
the
special judge?
That is right, my lord. Lord, could you see that?
Now, if you are saying that that is right, then you have to do the right thing.
My lord, my lord.
Now, what should I do?
I am leaving your at your lordship, my lord. But from the case, my lord, it appears that 21B is not attracted, only
Then we will have to call for the case diary.
lordship.
And on the next date, you also make your submissions that in an NDPS case, without approaching the special judge, can you approach High Court
My lord, I'm
under
satisfied.
439?
Yes.
Yes, some special. Otherwise, we may refuse to exercise.
My lord. Lordship, make call for the diary, my lord.
Okay. Heard Mr. P. Hajorika, learned counsel for the petitioner. Also heard Ms. S. Jahan, learned additional public prosecutor. Perusal of the case diary is felt necessary for consideration of the instant bail application. Hence, call for the case diary. Fixing when
Was after vacation, right? So. He knows.
16.
Before vacation, it can be try once, my lord. If it is possible, otherwise it will go after vacation.
Okay, that is your
My lord.
own choice option because you have better options available.
My lord. Yes,
28,
20.
28.
My lord, 439, in this case, my lord, allegation of committing offense under section 380 and 457, my lord, IPC. He was arrested on 25/2024, my lord. As on the 32 days in custody. Lordship will find the Azahar at page 15 is the vernacular, my lord.
Why it was rejected?
Rejected, my lord, yes, my lord.
Where is the rejection order?
Rejection order is at page 17 and 18, my lord.
After perusal of the case diary,
My lord,
when we have to peruse the case diary.
my lord.
Heard Mr. P. Hajorika, learned counsel for the petitioner. Also heard Ms. S. Jahan, learned additional public prosecutor. Considering the nature of allegation level in the FIR, again, the perusal of the case diary would be necessary, hence call for the case diary.
He is requesting for 28.
28, my lord, before which already 32 days in custody.
Lakhimpur Bus.
Okay. Fixing 28 for case diary. জি এটা পেজ আছে আরো দিব ওকে 28
Obligation.
Hey, Peter, so this is a 439 application, my lord. Gorsuk PS, my lord, under section 379. At this stage, may I pray for case diary, my lord.
Heard Mr. M. J. Kadir, learned counsel for the petitioner, also heard Ms. S. Jahan, learned additional public prosecutor. Call for the case diary.
Gorsuk PS, my lord. Guwahati.
When?
22nd. 27. 27.
27 he is requested.
Fixing,
Maybe the next week will not be possible.
fixing 27 for case diary.
All right.
May please, your lordship. Lordship 439 bail application, lordship. Offense, lordship, under section 153(a)(34) of the IPC, read with section 13(1) of the Assam Cattle Preservation Act, lordship. And lordship, today is 8 days in custody, lordship. Lordship will find the FIR page number.
Case
lordship.
diary would be required, Mr. Hassan.
Certain meat were recovered from the hotel, and the petitioner was working as a cook, lordship, in that hotel, lordship. Certain, that too, lordship, 2.39 kg roasted meat, lordship.
Why it was rejected?
It was rejected on because we moved on the first day before the learned CGM, lordship, considering the nascent stage of investigation, lordship. Those items, lordship, already, lordship, recovered, lordship, seized. And he was working as a cook in the concerned hotel, lordship, Bismillah Hotel. And
Where is the,
lordship,
which police station?
Jalukbari, lordship.
Case diary would be required.
He just visits the nearby. There.
Okay.
The lordship FIR was lodged by lordship one SI, lordship, of the outpost. So no, lordship, individual complain about that, lordship.
Not necessary.
Not necessary, lordship.
Heard Mr. N. Hassan, learned counsel for the petitioner. Also heard Ms. S. Jahan, learned additional public prosecutor. Perusal of the case diary would be necessary. Hence, call for the case diary. When?
28, 27.
28, lordship.
28. For case diary.
God bless.
May I please, your lordship. Lordship, 439 application, lordship. Offenses, lordship, is under section 20B, Roman 2C of the NDPS Act 1985 as amended.
Charge sheeted case.
Lordship.
Charge sheeted case.
Lordship, trial is going on, lordship, before the Honorable Court of Additional.
When were you arrested?
Lordship, 15/11/2021, lordship. HS, I have been behind the bars of Lokhra Jail, lordship, for 2 years, 6 months, 26 days, lordship. Until date, lordship, no evidence of PW has been adduced before the learned court, your lordship.
Anything? Yes. Heard Mr. A.K. Ahmed, learned counsel for the petitioner. Also heard Ms. N. Deka, learned counsel representing the NCB. Perusal of the scanned copy of the case record of special NDPS case number. What is the case number?
70. (73) 73 up to 2000.
You have not mentioned, it should be mentioned in the cause title.
Lordship, NDPS case number 73 of 2022, lordship.
73 of
2022.
2022, corresponding to NCB crime number 28/2021. From the, where it is pending?
Lordship, before the Honorable Court of Additional Session Judge 5,
From the court of
Kamrup
learned
Metro, Guwahati.
learned additional session judge number 5, Kamrup Metro, Guwahati. The registry shall take steps for requisitioning the aforementioned scanned copies. Let this case be listed after vacation, 16 July.
Obliged.
Maybe this is a 439 bail application under section 120B, 354 and reduced section 12 of the code.
So,
So good.
My lord, kindly pass over for the timing, my lord. Youngest council is on lake, my lord. Item number 9.
Nine.
Item 9.
Oscar Mandan is absent.
he's absent.
Sigma of account. Or you can take it up after some time.
After some time. After some.
The report was called through the registry. I don't know whether it has come. It is not reflected in the report.
Same has not received. None appears for the applicant on call. It appears from the office note dated 19/6/2024 that the report which was called for by this court by order dated 28/5/2024 has not yet arrived, has not yet been received. Registry to issue requisition, registry to issue reminder. Why it was called for by registry?
That is what even I'm wondering. Normally we bring the.
Yes. Let the learned additional public prosecutor is requested to remind the officer in charge of Kotkoti Police Station to furnish the report which was called for by this court by order dated 28/5/24 before the next date fixed. Let this case be listed after vacation. Give a date. 22nd July.
Yes, Your Lordship. We have, the petitioner hearing has come for quashing of a proceedings pending before the Judicial Magistrate First Class here under Section 138 of the Negotiable Instruments Act. If Your Lordship kindly peruses the order of cognizance at page 39. Probably this will not be a case under 138. because Here, Lordship, initially after, as it is done in complaint cases after initial deposition, evidence and affidavit, cognizance was not taken. The bank's manager was called for because it was not clear on due to what reasons the check was dishonored. And the bank manager deposed that the account was frozen due to non-updation of the KYC by the petitioner. And that is why the check was dishonored. Now the learned court below has presumed that if Your Lordship takes up page 39, the third paragraph, on consideration of the complaint petition, the evidence in affidavit and examination of witness, it is found that account block is one of the reasons for dishonor of the check. Although it is not specifically found whether account block is also responsible for bouncing the check, but account frozen is one of the reasons for dishonor of the check, and account frozen is similar to account block. Above all, it is the accused who is primarily responsible for blocking of the account and subsequent dishonor of the check. Hence, upon due consideration, it is found that prima facie there are sufficient grounds for proceeding. Accordingly, cognizance of an offence under Section 138 of the.
Now, at what
Act.
stage it is pending now?
Lordship, appearance stage, the petitioner.
Because cognizance was taken in the year 2021.
21, but we received.
Now it
notice-
is
We received
24.
notice only in the month, last week of May 2024. And thereafter, on 6th of June, the date was fixed for appearance. The petitioner, she is more than 91 years old. She's at present residing at Gurugram. Initially, at that point of, there is a story behind this. This apart from this legal provision, which requires examination, whether this will be a proceedings, whether proceedings under 138 will lie or
But
not.
we don't know.
That apart, Lordship, there is one more aspect. The complainant had stolen the entire bank record of the petitioner and her husband, who were at that point of time residing outside India. In fact, they are doctors by profession and they used to reside at Dubai at that point of time. They are permanent residents of Guwahati, of course. They had come to Guwahati in connection with sale of their immovable property. And these complainant, he posed himself as a real estate agent. And he struck up a rapport with them. And thereafter, he stole all their bank documents and other things. We have lodged 2 police complaints at that point of time in the year 2017 itself. These are on record. If your lordship kindly peruse it, it pays 40. Pays
No. but-
43, the first.
But that would be your defense in the
No,
case.
Yes, these,
But
we-
why the prayer for quashing at this initial?
yes, prayer for quashing lordship, this may not be, the issue requires examination, whether this cognizance of an offense under 138 could have been taken. Because
Without what?
the learned court below has presumed that account blocked and account frozen are two.
There were other materials also, because
No,
the observation is on consideration of the complaint petition,
no,
examination.
if on consideration of the complaint petition, cognizance could have taken, then in the year 2018 itself, when the complaint petition was filed, this could have been taken. That was
Complaint
not.
petition was filed in the year 2000.
2018. This is it was not taken at that point of time. Only after for further inquiry, if your lordship kindly peruses page 31, the initial order after initial deposition of the complainant at page 31. Third paragraph. Order dated 21/6/19. Upon due consideration, prima facie, it is found that the check in question alleged to be issued by the accused was not dishonored.
When the complaint was filed,
2018. This is
2000
a case of 2018.
when the complainant was examined,
It appears from the order dated 21/6/19. On that date, he was examined. That is what is reflected.
that means we have to go through the case record. We'll call for the,
And that apart, lordship, the notice, the demand notice was never received by them because they themselves enclosed the postal tracking consignment report, and this does not indicate that it was at all sent to the complainant, the accused person.
no,
Both-
these are defenses. You have to show something
That
glaring
is
procedure.
one of the mandatory condition that needs to be fulfilled before an offense under 138 can be taken cognizance of.
No, whether this was not taken into consideration while taking cognizance.
These aspects were not taken into consideration. Only thing that was taken into for what reasons?
No, where is that demand notice which you are saying?
One notice is at page 26. 5/6/2018 it indicates.
What appears to,
And-
from your submission, that in the year 2018, complaint was filed and cognizance was not immediately taken.
No, 20.
And an inquiry was conducted under 202.
Yes,
Inquiry took time, and only after examining the witnesses in the year 2021, the cognizance was taken.
authorized representative of the bank was called for.
No,
and he
what,
was-
that cognizance was taken.
After that.
Where is the error?
Lordship, that issue, as I was already submitted, when the learned court below has proceeded on the fact that account blocked and account frozen are the same thing. So
That has to be examined.
that has to be examined. That
I think in
That
the
has to be
High
examined.
Court's decision, it says that
account blocked may be,
blocked will come within 138.
blocked may
Okay,
in certain
okay,
cases.
no, you can raise this plea. We will examine.
Yes,
We are
this has to
issuing,
be-
issuing
yes.
notice.
Yes. So in the meantime, the proceedings will be stayed, of course.
For stay, you don't have a good case at this stage, Only
Lordship-
after perusal of the
Lordship will kindly, the complainant as the petitioner is more than 90 years old. And as we have
No,
already.
for
the-
that you have other reliefs. You can pray for dispensing with
No,
her
of course,
personal
that is there.
appearance.
But Lordship, unless and until that is done, proceedings are stayed, Lordship, this will be, these proceedings will be a futility of examining
That
that
we have to
aspect without.
examine. Let the
Lordship-
records
Lordship,
come.
Lordship, without staying the proceedings and and taking up for
No, but
consideration
for
that is.
stay, you have to make out a case.
Lordship, on the face of it appears there is no ingredients of offense under 138.
It
Because
does
that,
not appear.
Lordship has, it is fallen from your Lordship that issue requires examination.
Yes, it
Yes,
requires.
so obviously, the complainant has not been able to make out a case that
No,
there are ingredients of.
the issue, what requires examination is whether block account and frozen account are same and whether it comes within the purview of 138. That
Yes.
Comes. I think there are.
she's saying,
No,
your
there are-
submission is
there
it does
are
not come.
differing decisions on blocked and frozen.
So only that requires examination.
Lordship, for that, Lordship, unless the proceedings is stayed, Lordship, these entire Lordship proceedings will be infutility, will
Not at this
become
stage.
infectious.
After, let the respondent appear, let us hear him. Then we will consider.
Appearing through counsels.
No, Lordship, Lordship only taking into, Lordship, that issue and taking into consideration also that fact that initially, that at that point of time itself, prior to the dishonor of the check, alleged dishonor, we had lodged police complaints against the.
No, those
complainant.
are relevant facts, but not at this stage.
Lordship,
This does
for-
not.
For the complaint, Lordship, at least for the Lordship, for making out a case under section one, because the rebut, we have a right of rebuttal also, Lordship, that these aspects will go into forming
No,
case under
the-
139 law.
For staying a criminal proceeding under 482, something glaring you have to point out.
Lordship, glaring, what I've pointed out is that on the face of it, the complaint petition does not make out a case under section 138.
No.
That is the glaring, Lordship, legal fault that is, if
Because
on the face of it, the complaint does not make out a case
why it does not make out?
under which it is.
Why it does not make out a case? Because the court has presumed it to be a block account. That is one reason.
Yes,
which-
presumed it.
So-
Reasons, yes, presumed it. And on, no, Lordship, that apart, the complainant has to, on the face of it, the complaint has to make out a case under which he has sought a relief or under which cognizance has been taken. That is what Bhajanlal says. If prima facie does not make out any case, then of course, Lordship, either the complaint or the FIR goes. That is one of the.
But it appears that prima facie there is a case.
Lordship, prima facie there is because it has fallen from the honorable court. This issue requires examination.
No, that
Whether
does
it-
not mean that after examination, there
Because,
is a distinction. It does not mean that whatever requires examination has to be stayed.
Lordship, can it come up on Monday? I'll satisfy your Lordship on that point.
Okay, okay. On the request of learned counsel for the petitioner, list this case again on 24th. Let it come on 25th. 24th, we are
25th, yes,
25th.
25th.
Please, Lordship, I'm extremely sorry, Lordship. My senior legs in court number 26 and the matter is going on, Lordship.
Hey,
So I mean.
which item?
9, Lordship.
But we have not called item number 9 now.
Oh.
9 is over.
9 is over.
Report, Lordship has called for a
9,
report.
9, we have already passed an order, which is not unfavorable order to you. You go through the order. We have called for the report. It is,
Senior will appear, Lordship.
No, report is called. I'll bring the report.
Much obliged.
show there, what is your name?
Lordship and Dekaraja.
Mr. Manan.
Mr. Manan,
Lordship.
show his presence in 9. We have called for a report. report has, PP will bring that report. And
Lordship has issued notice.
The report on.
Only the report.
Okay. No, it was brought, it was solved from the registry. I'll bring it. That
Okay.
was perhaps a wrong one.
That was zero. Anyway, not sure. Get your fix for you.
Lordship has been 22/7.
Not sure. May it please your lordship.
show the presence of the council. Yes.
Your lordship, the petitioner has filed the petition under section 482 for quashing of the CR case number 22 of 2022.
Watching of,
Complaint case number 22 of 2022.
okay,
Your lordship, the point in here is that the cognizance has been taken for an offense under section 420 of the Indian Penal Code and
420 of,
the IPC.
yes.
Your lordship.
What is the ground?
Well, your lordship, the basic point is it was a business transaction. The petitioner is engaged in the business of used, he's a second-hand car dealer. And the complainant, what happened, there was an agreement between them to deliver a used car. So as per the agreement, the complainant had paid me an advance of 50,000 rupees. And the balance 40,000 was supposed to be paid at the time of delivery. And because it was a purely in the nature of a failed business transaction, I intimated the complainant that I will not be able to deliver because there are certain business developments which took place during the course of this. And thereafter, I informed him that kindly take back the 50,000. But he insisted, no, I want the car. So thereafter, when he repeatedly, I told him, no, that would not be possible because there are many factors. So then he told me, you have to pay me 20,000 as an extra amount for the same, for not delivering the car. So I told him it amounts to extortion. So then he insisted, no, you have to pay me 70,000. So thereafter, finding no alternative, I told him, okay, I'm ready to pay 70,000, you withdraw the case. But because he demanded the amount of 70,000, your lordship may kindly.
No, what is the allegation in the complaint?
The allegation is that I have failed, intentionally not delivered the car to him. The complaint is on page 23.
Yes.
So your lordship, I am ready to pay the 50,000 rupees. In fact, it has come to a point where I was in fact ready to pay the amount of 70,000 only. So because I being a businessman, I'm seriously like my reputation, goodwill is at stake for just a failed business transaction. And now I am being vindicated and a case has been filed and he has repeatedly threatened me over phone. I will see to it that you get punished. But then I will not be able to do a business in the future also because if this is the scenario. So now I'm ready to pay the 50,000. So, but I have repeatedly requested him to give me the bank details. But what he is saying is that he has not replied. And there are actually 2-3 accounts to which he had made me the payment of 50,000. So I'm not sure which account. So today, if I pay him that 50,000 and he says, no, I have not received it. So that is also my concern. So if he gives me any definite account and I am ready to pay.
Let us issue notice, let him come.
Your lordship, and NBWA was issued, even though I had engaged a counsel because, but the last date there was some.
Why have you not appeared?
Your lordship, I stay in Kolkata and this complaint has been filed in the police station of Bokaghar. So, and what happened is that during the course of the entire proceedings, if your lordship may peruse the paragraphs number 4 and 5, your lordship, it is very evident that the complainant has repeatedly abstained from the proceedings and he has informed me, okay, I'm not appearing. So I'm basically, technically, I'm giving you more time in each and every occasion so that you can pay me. Out of 15,
he was absent in steps on 29/4.
Complaining.
The matter was that he accused. And the matter was fixed on 1st of June. 1st of June only the NBW is issued. Because on the 84, NBW can be issued to the accused on the very first day itself.
Do you have anything to?
Sir, the allegation in the complaint is that he did not deliver the vehicle of one or the other pretext. Once he said, so some kind of cheating is there. For if not 420, 406 will come.
Cognizance been taken
Cognizance
of
is
420.
420. And as well as 406.
No, 420. If you can peruse the order dated 25/8/2022, there is on page number 33. On the second page, it is mentioned.
Where is the complaint petition?
Complaint petition 23.
The allegation should be from he intended not to pay at the time of entering into the contract.
5 months in the complaint.
Your Lordship, it's a purely civil dispute. And if your Lordship may peruse the annexed here,
Right also that he had that intention from the very beginning.
if your Lordship may kindly peruse the page number 42, which is a translated copy of the email the complainant sent.
Okay. Heard Mr. A.R. Barua,
G.R. Datta.
G.R. Datta, learned counsel for the petitioner. Also heard Ms. S. Jahan, learned additional public prosecutor, who has received notice on behalf of received notice for the respondent number 1. This application under section 482 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, namely Shri Vikrant Jaiswal, alias Pappu Jaiswal, praying for quashing of the CR case number 22/2022, pending before the Court of Learned Subdivisional Judicial Magistrate within bracket M, Bokaghat, wherein cognizance of offense under section 420 of the Indian Penal Code has been taken by the learned magistrate against the present petitioner and processes were issued against him. Learned counsel for the petitioner has submitted that the petitioner had entered into business transaction with the respondent number 2 and had purchased.
No, I intend to purchase, but because of this failed transaction, business transaction, I was not able to deliver the car.
You
You are the seller.
I am the seller. Yes, I am the seller.
Had entered. So there was some agreement.
It's an oral agreement.
There was discussion over telephone regarding purchase of a car within, that is Centro within bracket Hyundai GLS Met car bearing registration number 02Z-5215, of which you are the owner.
I'm not the owner. I'm a second-hand used car dealer.
Which is to be provided by the, which was agreed to be provided to the complainant/respondent by the present petitioner at an agreed amount of rupees 90,000. Stop. Whether car was delivered?
No, the car was that was the piece of contention because I failed to deliver the car. Because your lordship will take into consideration so many factors were involved. Being a used car dealer, I was. And
Mhm.
therefore, I immediately promised to refund the amount, advance amount of 50,000. Yes.
50,000 was paid.
Paid to-
Okay. And in this connection, and in this regard, an amount of rupees 50,000 was paid by the respondent number 2 to the present petitioner as an advance money for the said transaction. However, it is alleged that the petitioner failed to either deliver the said car or repay back the advance amount to the respondent number 2. Hence, alleging cheating on the part of the present petitioner, the respondent number 2 instituted the complaint case bearing, which was registered as CR case number 22/22. Learned counsel for the petitioner has submitted that during the course of the transaction, some dispute arose between the.
There was no dispute actually, your lordship, as genuinely it was a failed business transaction.
No, the learned counsel for the petitioner has submitted that this is a case of failed business transaction where the car in the question was not delivered
Because the
to the
complaint.
to the
Respondent number.
Complaint.
to the complainant,
Taken 50,000, but did not deliver the
and it is further submitted, though the petitioner offered to repay back the advance amount of rupees 50,000. However, he was asked to pay an additional 20,000.
That is, no, kindly, your lordship, kindly produce page number 42.
That is your submission.
That is my submission, it's part of the record also. I annexed an
No,
email.
I'm reflecting your submission on
Yes.
20,000. However, why that he did not receive the 20,000?
No, actually he had paid me an advance of 50,000 rupees. And so when I told him that I am unable to deliver the car, so he demanded that because I failed to deliver, he has now I have to pay him an additional amount of 20,000 as a compensation. I don't know what was his intention behind it. So you have to pay me 70,000 rupees. So initially I told him you cannot extort this amounts to extortion. So he informed me, no, I will file a case against you if you don't meet the 70,000.
So a dispute arose between you and.
Yes.
And regarding the demand made by the respondent number 2, a dispute arose and it is arose between the party, and it is submitted by learned counsel for the petitioner that the instant complaint case has been filed by the respondent number 2 only to pressurize the present petitioner. Learned counsel for the petitioner submits that the dispute between the parties is in the course of a business transaction and purely civil in nature. And there was no initial there was no initial intention to deceive on the part of the present petitioner, neither it has been alleged in the complaint petition. Learned counsel for the petitioner has submitted that the petitioner is still ready to repay back the advance amount of rupees 50,000 to the respondent number 2.
Bank details.
Stop. Issue notice to the respondents, since learned additional public prosecutor has already appeared. no formal notice need to be issued to respondent number one. As regards respondent number two is concerned, the petitioner shall take steps for issuance of notice to respondent number two by registered post with AD within 3 days from the date of this order. Returnable, give a date.
Your lordship, in the meantime, stay of the proceedings.
Returnable on 24th July. However, stop. In the meanwhile, considering the fact that apparently it appears that the dispute between parties arose out of business transaction and appears to be predominantly civil in nature, the further proceeding of CR case number 22/2022 is hereby stayed till the next returnable date. The operation of non-bailable warrant of arrest issued against the present petitioner shall also remain suspended during this period.
Your lordship, can it be on 29th of July instead of
29 July.
Obliged,
List accordingly.
No, this is against issuance of warrant of arrest, non-bailable warrant of arrest. Now, may I take your lordship to page 30?
Page
30. This is a NI case, my lord. In an NI case, warrant of arrest has been issued. My lord, page 30, order dated 29/9/2023.
Just
30.
yes.
Order dated 29/9. I'm reading it, madam. Both the parties are present along with their engaged counsels. The accused has stated that he has been paying the money of the check amount in installments, and today also he will pay money to the complainant, and compromise stock outside the court is going on. Accused has assured that the other party to pay at least 80,000 of the check amount before 16/11 in an outside court settlement. Complainants had agreed, hence it is fixed on 1/11. 1/11. Complainant present, accused is absent. Peruse the case record, which reveals that on the last date, the parties have prayed to fix 16/11 as the compromise talk is going on, and the accused on that day has assured to pay the other party some amount of money in order to compromise the case. It is seen that the case is fixed today due to mistake, and hence the accused is absent. Hence, the next date is fixed on 16/11. Now, 16/11, my lord, will find at page 33. 33. Page 33. No. Am I with your lordship, my lord? Page 33.
Yes.
Order 16/11. Next date. Next date after 1/11 is 16/11, my lord. On this date, NBW has been issued.
Yes.
Advocate for the complainant has filed Hajira. Accused is absent with steps, white petition number so and so, showing cause of absence, but the petition is not moved by any advocate. Peruse the case record, which reveals that on 10/7/2023, NBW was issued against the accused, but he appeared later and stated that compromise has been initiated and he has paid even some money on that day up to the complainant. On the next date, the accused remained absent on 29/9/2023, accused again appeared before the court and stated that he would pay at least 80,000 to the complainant today in an amount of settlement. But the accused remained absent today, and his petition is also not pressed by any advocate. Hence, the petition is rejected. Issue NBW against the accused. Complainant shall take step. Now, my lord, my lord has seen on the other two dates, my lord, the petitioner was present on on the other date, on 1/11, he could not be present as the date was mistakenly fixed. That has been recorded.
But on 16, you knew that it was fixed.
Yes, that a petition was placed, but that was not pressed by the engaged counsel. That is why NBW has been issued.
Now, when is the next date fixed?
Next date is, my lord, on 2/8/2024. We'll go and appear before that date, my lord.
No,
And
but
we have been,
after that date, on several dates, the case was fixed.
The lordship is 4/6. There was a petition for recalling the NBW that was not.
that was also not allowed, my lord.
When?
On 4/6, my lord, page 34. Page 34. On the last date, my lord. On 16/11,
Your counsel appeared.
the council appeared, my lord, on that day.
The next date is 2nd of August.
Yes.
Let him go.
Let him appear. Let him appear.
Go and
Okay.
appear
We'll
on
go and
2nd.
appear, my lord. Let the NBW be suspended, my lord. We'll go and appear.
Heard Mr. P.K. Munir, learned counsel for the petitioner. Also heard Ms. S. Jahan, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Shri Priyanko Borua, impugning the order dated
16/11/2023,
passed by learned additional Chief Judicial Magistrate Nagaon in NI case number 88/2017,
Right.
whereby non-bailable warrant of arrest was issued against the present petitioner. Stop. Learned counsel for the petitioner has submitted that the respondent number 2 had filed an NI Act, file a case under section 138 of the NI Act, 1888, alleging dishonor of check issued by the present petitioner. It is submitted by learned counsel for the petitioner that a talk of compromise was going on between the parties, and on 29/9/2023, both the parties appeared before the learned additional Chief Judicial Magistrate Nagaon and informed the court that by 16/11/2023, what was the check amount?
3,30,000.
16/11/2023, an amount of rupees 80,000 out of the check amount would be paid by the petitioner to the
Till date, 1,25,000 have been paid.
to the respondent number 2. Stop. Learned counsel for the petitioner has also submitted that till date, out of the check amount of rupees,
1,25,000.
what is the check amount?
3,30,000.
3,30,000.
30,000.
The petitioner has already paid an amount of rupees
25,000.
1,25,000.
Mhm.
Stop. It is further submitted by learned counsel for the petitioner that on 16, that the CR case number, the NI case
NI.
number 88/2017 was thereafter wrongly listed on 1/11/2023, and the next date was fixed on 16/11/2023. Stop. On the said date, the petitioner could not appear before the said court. However, he filed
Yes,
an adjournment application through his engaged counsel
White petition number 5742.
by filing a petition bearing number 5742/2023. However, the said prayer was rejected, and the learned additional Chief Judicial Magistrate Nagaon issued non-bailable warrant of arrest against the present petitioner. It is further submitted by learned counsel for the petitioner that the engaged counsel for the petitioner had again appeared before the trial court on 4/6/2024 and filed an application for recalling of the NBWA issued against the present petitioner. However, the said prayer was also rejected by the learned additional Chief Judicial Magistrate Nagaon. Stop. Learned counsel for the petitioner has submitted that the said NI case is next fixed on when?
2nd of August.
2nd of August 2022.
24.
To 2024, and the petitioner is ready to appear before the trial court on the said date. It is also submitted that still compromise talk is going on. That as a talk of compromise is going on, if the petitioner is detained, it may vitiate the possibility of compromise between the parties. Stop. Considering the submissions made by learned counsel for the petitioner, this court is of opinion that as the petitioner is ready and willing to cooperate in the trial, and as a talk of compromise is going on between the petitioner and respondent number 2, he may be afforded an opportunity in appearing before the trial court on the next date fixed. Hence, this criminal petition is disposed of with a direction to the petitioner to appear before the trial court, that is the Court of Learned Additional Chief Judicial Magistrate Nagaon in NI case number 88/2017 on the next date fixed, that is 2nd of August 2024. And stop 2024. To facilitate such appearance by the above named petitioner, the operation of non-bailable warrant of arrest issued by the Learned Additional Chief Judicial Magistrate Nagaon against the present petitioner shall remain suspended till 2nd of August 2024. On his appearance before the trial court, the petitioner may seek any relief to which he is legally entitled to. With above observation, this criminal petition is disposed of.
Much obliged.
May it please Lordship. Lordship, this is also regarding issuance of NBWA against the petitioner. Well, the petitioner was never interrogated by the police. Lordship, may I kindly turn to the order sheet. Entire order sheet has been annexed, my lord. Starts at page 23.
This is PRC case.
PRC case, Lordship. Lordship, cognizance was taken on 2nd of April. Lordship, page 23, Lordship has got it, man.
23.
23.
Yes.
On 2nd of April 2019, cognizance was taken by the learned CJM and matter was transferred to the Judicial Magistrate First Class.
Yes.
And next page, my lord, the learned trial court issued notice. And Lordship may come to, for a moment, come to page 29.
No, you appeared.
No, I didn't appear. There were 4 accused, my lord.
Declared an absconder, no?
They are absconder in the charge sheet. Yes.
Said to be an absconder.
On the Lordship, kindly turn to page 29, my lord. Accused, may I read, my lord?
No, before 29, there are many orders.
Yes.
On 19th, Lordship, you see page 25. Samsar Boro are absent without any step.
I didn't appear. Turn to Lordship, turn to page 24.
What is your name?
Samsar Boro. There were 4 accused in the charge sheet, my lord.
Okay.
Charge sheet is at page, translated copy at page 17. 1 Dimu Boro, petitioner Samsar Boro, 1 Rahul Basumatari and Ajay Chaudhary. These 2 were appeared. It appears, though it has not been clearly recorded, Accused are present and represented. The
Which
accused,
order you are reading?
no, but I'm reading at page 24, order dated 3/7/2019.
Yes, it mentions accused are present and represented,
Yes.
which implies that all accused.
No, my lord, the petitioner never appeared. In fact, petitioner has never received any summons, nor petitioner was even interrogated by the police at any point of time. I have made a specific statement
Okay,
in this case. It has probably referred to the other two accused, my lord. Yes.
As far as Samsar Boro, he was not present. He was absent without any step. Summons were issued and thereafter NBW.
Lordship, kindly turn to page 29 for a moment, my lord. 29 will clarify, my lord.
Yes, yes.
Lordship, may I kindly peruse the order dated 9th of December 2021.
Yes.
Accused Rahul Basumatari is present. Co-accused Ajay Chaudhary is absent with step and by petition number so and so he has showed cause. Heard the petition as allowed. Co-accused Dimu Boru and Samsar Boru is absent without any steps. Summons issued to the accused Dimu Boru and Samsar Boru has not yet returned. Immediately on the next date, my lord, it was fixed on 4th of April. On 4th of April, just down below, my lord. Accused Rahul Basumatari and Ajay Chaudhary are present. Other co-accused are absent without any step. It appears from the search sheet that accused Dimu Boru and Samsar Boru were absconding. Well, I have made specific statement at paragraph 6.
Okay.
That I have never absconded. My petitioner at never point of time.
No, after issuance of summons, the court did not waited for the service report.
Yes, yes. And my next date is fixed on, my lord, 24th of July, 2024.
Summons issued a number of times.
Yes, madam, many times.
December, Lordship, the summons had not yet returned. So they waited. Thereafter, they issued NBW.
No, but without ensuring that summons were served on
Served
the
upon them.
Does not,
mere issuance is not enough,
had not returned. This is what.
had not returned. So whether it reached the accused or not, there is
Whether
no
it means
indication.
Not required.
Heard Mr.
D. Chakraborty.
D. Chakraborty, learned counsel for the petitioner. Also heard Ms. S. Jahan, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, namely Samsar Boro, impugning the order dated 4. No, by which order the
Initially, it was issued.
No,
the
NBW was issued
4/4/2022 and all subsequent orders.
impugning the order dated 4/4/2022 and all subsequent orders passed in PRC case number 839/2019 by the learned Judicial Magistrate First Class number 2, Kamrup Metro, whereby non-bailable warrant of arrest was issued against the present petitioner. Learned counsel for the petitioner has submitted that. Where is the FIR?
Lordship, FIR starts at translated copy at page 21 and vernacular, Lordship. Sorry, Lordship, my lord, FIR. Page 13 is the translated copy and vernacular is at page.
That on the
16.
basis of an FIR lodged by one Rajkumar Das,
The Fatashil police station.
before the officer in charge of Fatashil police station on 21/11/2008, alleging theft of his Tata Sumo vehicle, theft of his Sumo Gold vehicle bearing registration number AS01FC 7644. A Fatashil PS case number 489/18 was registered under section 379 of the Indian Penal Code and investigation was initiated. Where is the charge sheet? Ultimately, on completion of the investigation,
Page 18, my lord.
charge sheet was laid against 4 numbers of accused persons, including the present petitioner. under section 379/34 of the Indian Penal Code. The name of the petitioner, namely Sansar Boro, has been shown in column number 2 of the charge sheet as an absconder. Learned counsel for the petitioner has submitted that the petitioner was never approached during investigation by any police, and he is not aware about pendency of any case against him. It is also submitted by learned counsel for the petitioner that after filing of the charge sheet, the PRC case number 8839/2019 was registered, and same was transferred for disposal to the Court of Learned Judicial Magistrate First Class.
Number 2.
Number 2. It is also submitted by learned counsel for the petitioner that from the order sheet, it appears, petitioner, that the said court, that is the Court of Learned Judicial Magistrate First Class, Kamrup Metro, issued summons to the present petitioner on several occasions, but he never received any summons from the said court. It is also submitted by learned counsel for the petitioner that by order dated 9/12/2021, the Court of Learned Judicial Magistrate First Class, Kamrup Metro, issued summons for the last time to the petitioner, and thereafter on 4/4/2022, without waiting for any report of service of the summons issued by the said court to the petitioner, the learned magistrate issued non-bailable warrant of arrest against him only because of the fact that the name of the present petitioner has been shown as an absconder in the charge sheet. Stop. I have stop. On perusal of the copies of order sheet annexed along with the criminal petition, it appears that the Learned Judicial Magistrate First Class, Kamrup Metro, had issued summons to the petitioner Sansar Boro on 9/12/2021, as earlier summons issued to the said to them were not returned. However, it also appears that on 4/4/2022, without there being any indication of receipt of service report as regards the summons issued to the present petitioner, the learned magistrate issued non-bailable warrant of arrest against the present petitioner only, and it appears that same was done by the learned magistrate because the name of the present petitioner appears in the charge sheet in column number 2 as an absconder. This court is of considered opinion that before issuing non-bailable warrant of arrest, the magistrate ought to have ensured receipt of service report of summons issued to the petitioner by it. Hence, an opportunity stop. Learned counsel for the petitioner has also submitted that the PRC case number 839/2019 is fixed on
24/7/2024,
24/7/2024, And as the petitioner is ready and willing to appear before this trial court on the said date, an opportunity may be afforded to the petitioner to do so. In view of the above facts, this criminal petition is hereby disposed of, but with a directions to the petitioner to appear before the Court of Learned Judicial Magistrate First Class Kamrup Metro in PRC case number 839/2019 on 24/7/2024, and to facilitate such appearance by the petitioner, the non-bailable warrant of arrest issued against him by the said court shall remain suspended on his appearance before the Court of Learned Judicial Magistrate First Class Kamrup Metro on the aforesaid date. The petitioner may pray for any relief to which he is legally entitled to before the said court. With this observation, with above observation, this criminal petition is hereby disposed of.
Deeply obliged.
I say, madam. May I please? My lord, the petitioners were apprehending of arrest, and he inquired in the police office as well as the PI court, but there is no case is pending against him. Despite that situation, my lord, he was.
No case is pending.
Yes.
Then why are you apprehending?
Yes, because my lord, lordship kindly see page 14. I have narrated the exact situation, my lord, page 14.
Page 14 is the FIR.
My lord, this is FIR lodged by us, the petitioner, before the superintendent of police. Two occasions, my lord, on 30/5/2024.
You have lodged an FIR against the constables and home guard.
My lord.
Now, in which case you are apprehending arrest?
There is no case.
Then
But-
what protection you are
Yes,
seeking?
but without case, my lord, they have searched my house, even without a search warrant. I inquired in the PI court as well as the my lord, police office, my lord, no case is pending. Now that will be, my lord,
Then whether in an anticipatory bail any relief may be granted to you?
now in the last occasion, my lord, some interim protection was there.
In the interim protection only to find out whether there is any case pending against you or not. Now, as there is no case is pending, report has come from OC. There is no apprehension because nobody can arrest you without a case.
Yes, that's true. But they searched my house.
Now, what protection you are seeking? What relief you are seeking?
Now, since no case is pending, admittedly, my lord, there is no apprehension. But facts remain that twice, my lord, they searched my house.
No, what relief you want? You tell me what relief you want.
But,
If you don't want your any relief, then withdraw this case.
But since no case is pending, with that observation, my lord, the petition may be, my lord, closed.
Heard, Mr. Mr. M.U. Mandal, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor. Learned additional public prosecutor has submitted that she has been, you have received report. She has received, submitted that. She has received a report from the Which, from whom you have received? From officer in charge of Bilasipara Police Station in pursuant to the order dated 11/6/2024 passed by this court earlier, that, and she has been informed that no case is pending against the present petitioner in Bilasipara Police Station. Stop. In view of the aforesaid fact, this anticipatory bail application has become infructuous and accordingly closed.
Obliged.
May I please your lordship? 438 application lordship, this case has a long history lordship. Both the parties are family members. A long dispute was going on. Lordship may kindly peruse the first FIR at page number 22, which was filed by the petitioner's wife against his brother, who
POCSO
is the
there.
present complainant.
There is no allegation against the present applicant or he is connected with the alleged offense. But why he is appearing, I will place it for your lordship.
What is the allegation in the, what is the accusation in the FIR?
Accusation in the FIR, lordship may kindly note the vehicle number mentioned herein, AS07L5931. That was intercepted by the police, and from there the driver and one passenger fled away. And subsequently they found some articles, that is gelatin stick, 1800 piece of detonator, 4 bundle of safety fuse wire, 1 exit battery, small size. Those were recovered and accordingly FIR was lodged. Now why I am apprehending, lordship may kindly see page 14. This vehicle is different. That number your lordship will find top portion. This is a registration number AS01FQ8942. This is different vehicle which is mentioned in the FIR. This owner's name is Asadul Sheikh. In the top portion your lordship will find. I have purchased this vehicle. That purchase lordship will find.
Which
that,
vehicle? Vehicle at page 14.
Page 14.
That you have purchased.
That I have purchased.
Okay.
And subsequently for happened lordship, I have leased it to one, that page 16 is the document I have purchased. Page 16 lordship may kindly see. Asadul Sheikh, that was the owner I have shown to your lordship. My wife purchased, Angura Khatun. And thereafter, we lease it to one person named Biswajit Nath. Page 19, your lordship will find that this purchase is subsequent to FIR. That it is 2nd February 2024, this purchase.
Your purchase?
Yes.
Okay.
And I lease it to one Biswajit Nath. Page 19, your lordship will find Angura Khatun, wife of Akbar Ali, or daughter of Akbar Ali, wife of Anwar Hussain. That is Anwar Hussain is petitioner.
After purchase, you lease it.
Lease it to Biswajit Nath. Now, subsequently, lordship, what happened? My vehicle, along with the driver, was apprehended. Page 23, your lordship may kindly turn. That main purpose of the police was to apprehend Biswajit Nath. But as he was driving the vehicle, which was in my custody, owner, which was in my name, lordship, that vehicle 48942, and his forwarding report I have annexed, that your lordship will find page 20.
Biswajit Nath was
Apprehended.
arrested in connection with this
That
case.
case. That FIR.
Why he was arrested?
Because it was suspected he was the driver who fled away.
Okay.
And thereafter also what happened, police issued 141 notice that your lordship will find.
To you?
To me, lordship. Page 28. But as the case is punishable more than 10 years, so he apprehended that if he goes there, he will be apprehended. And 41 notice itself shows that my custodial interaction is not required, lordship.
So why you are apprehending? Then nobody will go honor 41A notice.
No,
The purpose of 41A notice is?
No, as per lordship, Satyendra Kumar until judgment and Ernest Kumar lordship, that if it is punishable less than 7 years, then they can issue notice. But here punishment is more than 7 years.
Still they have issued.
Still they have
But
issued.
there
So
is no
my
bar.
apprehension is that if I go there, so they will put me behind bar.
Okay.
Only because of that.
Yes. Okay, heard Mr. A. Azad. Learned counsel for the petitioner also heard Ms. N. Das, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Anwar Hussain, who is apprehending his arrest in connection with Dhupdhara PS case number 9/2024 under section 120B/336/34 of the Indian Penal Code, read with section 4/5 of the Explosives Act, 1955. What is the year of the Explosive Act?
Explosive Substance Act, Lordship, 1884.
1884.
Sorry, Lordship, 1908, sorry, 1908.
Explosive Substances, 1908. The gist of accusation in this case is that on 17/1/2024, one B. Goyari, SI of police, had lodged an FIR before the officer in charge of Dhupdhara police station that on receipt of an information through reliable sources, a Naka checking was conducted in front of Dhupdhara police station at about 6:30 a.m. on 17/1/2024, and one vehicle bearing registration number AS07L593 was intercepted. Stop. The vehicle did not stop on the Naka checking point and broke the Naka checking barricade and proceeded towards Gwalpara. Later on, the said vehicle was chased by the police party and the same was intercepted at Gatiapara under Dhupdhara police station. The driver and co-passenger of the said vehicle managed to flee away. The police searched the said vehicle and found that there were a large quantity of explosive substance from the said vehicle. On receipt of the said FIR, Dhupdhara PS case number 94/2024 was registered. Learned counsel for the petitioner has submitted that the petitioner is in no way involved in the offense alleged in the FIR. However, he had, after full stop, however, it is submitted by learned counsel for the petitioner that the petitioner had purchased one what vehicle?
Bolero vehicle.
One Bolero vehicle bearing registration number. No, the wife of the petitioner has purchased one Bolero. Wife of the petitioner has purchased one Bolero vehicle bearing registration number AS01FQ8942 from one Arshidul Sheikh, and later on gave the said vehicle on rent,
On lease.
on lease to one Bishwajit Nath by entering into a lease agreement on the 13th day of February 2024. Learned counsel for the petitioner has submitted that the purchase of the vehicle by the present petitioner and giving the said vehicle on lease were done after the date of filing of the FIR in the instant case. It is further submitted by learned counsel for the petitioner that in the meanwhile, police had arrested the said Vishwajit Nath in connection with the arrest, in connection with the instant case, suspecting him to be the driver of the vehicle bearing registration number RC, registration number AS07L593. 5931. Learned counsel for the petitioner has submitted that thereafter on notice dated
Notice dated is not there, Lordship. It was directed to appear on 9/6/2024 at 11.
have received a notice from the notice under section 41A of the Code of Criminal Procedure, 1973, from the officer in charge of Dhupdara Police Station in connection with the Dhupdara PS case number 9/2024, directing him to appear before the appear at Dhupdara Police Station on 9/6/2024. Learned counsel for the petitioner has submitted that as the offense involved in this case prescribes punishment for more than 7 years. The petitioner suspected that if he appears in the said case, he may be arrested by the police, and therefore he defaulted to appear on the said date. Now the petitioner apprehends that he may be arrested in connection with Dhupdara PS case number 9/2024, though he is in no way connected with the offense alleged in the FIR. Learned counsel for the petitioner has also submitted that the petitioner is ready and willing to cooperate in the investigation. On the other hand, learned additional public prosecutor submits that perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the case diary, fixing 16/7 for case diary. However, in the meanwhile, considering the submissions made by learned counsel for the petitioner as discussed herein above, the petitioner, namely Anwar Hussain, is directed to appear before the officer in charge of Dhupdara PSK, appear before the investigating officer of Dhupdara PS case number 9/2024 within a period of 10 days from the date of this order and cooperate in the investigation. If he does so within the stipulated period of time, in the event of his arrest in connection with the Dhupdara PS case number 9/2024, the above named petitioner shall be allowed to go on bail of ₹30,000 with one surety of like amount, go on interim bail of ₹30,000 with one surety of like amount, subject to the satisfaction of the arresting authority, with following conditions. Condition number 1 and 2. List this matter accordingly.
Obliged, Lordship.
My lord, FIR is, my lord, page 12, no, page 18, my lord. Allegation is very serious. However, my lord,
Page 18,
page 18, my lord.
page 18 is not there.
My lord, page 12, my lord. My lord, I'm sorry, page 12.
Yes.
Now, one co-accused, my lord, accused this noble code and notice was issued. And thereafter,
What is your name?
my name is, my lord, Babul Sheikh. Babu Sheikh.
Number 1.
Yes, number 1. And you also kindly say page 15.
Case diary would be required.
My lord, page 15, my lord. That case is fixed on 25/6/2024. It was called for. And after perusing the case diary, then one accused was granted interim bail.
After
because
perusal of the case diary.
Case diary. He was granted interim bail. However, the CD was returned back and called for after the CD, my lord. The allegation level is the FIR as well as her statement 161 as well as her statement under 164 CRPC quite contradictory. That is why this noble court granted bail to him in protection given. So, my lord, this matter will listed on 25 along with that.
Heard Mr. J. Ahmed, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor.
Yes,
Issue
yes,
notice to the respondent. The petitioner shall take steps for issuance of notice on respondent number 3. Who is the respondent number 2?
Respondent to notice may be issued, my lord. Informant.
Non-respondent number 2. As per the notification number 17 dated 15/3/2024 issued by the registry of this court. Learned counsel for the petitioner has also submitted that since that the co-accused in this case, co-accused of this case had preferred an anticipatory bail.
Application, so 438 application, Lordship. FIR page 8, Lordship. The allegation is that petitioner issued fake appointment letter to the informant and misappropriate money by taking loan.
Where is the FIR?
Page 8, Lordship.
Page 8.
Lordship.
What is the allegation?
Allegation is the petitioner issued a fake appointment letter to the informant.
Fake appointment letter.
And misappropriate money by taking. Actually, they are taking loan. He is help the informant by taking loan.
Case diary would be required. Heard Mr.
B. Islam.
B. Islam, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor. Case diary would, perusal of the case diary would be necessary for consideration of the instant bail application. Anticipatory bail application. Let this case be listed on 28/6.
Most obliged.
Please, Your Lordship. Lordship, Mr. D. Gogo is the engaged counsel for this matter. He is on legs in court number 1. So matter may be taken after some time. Nice.
This is a bail application, my lord. The informant is, my lord, working under me last 22 years. And he lost an FIR, my lord. We helped him throughout, my lord. But at the end, my lord, the dispute was with regard to a Innova car, my lord. Your lordship may see page 22 is the FIR, my lord.
Page 22.
22. That the gist of the case is that, my lord, that he got financial assistance from me, the accused petitioner, my lord, who is also a government employee, my lord. So
You are a government employee.
employee, my lord. So he took a financial assistance around 23 lakhs from me. He wants to say that he has returned back 54 lakhs, an odd amount. And subsequently, my lord, the petitioner demanded 10 lakhs extra. So a vehicle was purchased in the name of, my lord, the informant, my lord. That vehicle, my lord, we have surrendered it before the police station, my lord. So there is no dispute to that effect. Lordship,
No, what is the allegation?
yes, allegation, Lordship, with due respect, I would like to inform you that I.
The gist of allegation,
Gist of that, my lord, yes.
you gave, no, who took 23 lakh loan?
23 lakhs from me, my lord.
The informant took
Yes.
financial assistance of
Yes,
so and
with
so
effect
from,
12/4/2021 to 13/9/23.
why? For purchasing Innova?
No, 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 lord. He is taking loan from time to time, my lord, for his business, my lord.
Okay.
He was under me, my lord, last 22 years. Then he said that he will start his independent business. So I was helping them, my lord, him, in fact, my lord. And then he said that he has returned 54 lakhs. Now there is no calculation that how he has returned back.
No, but the allegation is at the time of taking loan, she gave her, the informant gave his or her,
Her, my lord.
her Innova to you.
No, Innova was purchased in his name, my lord. But that down payment has been done by one of my friend. I enclosed the bank statement. Then, my lord, the check also he has deposited with me. Now, my lord, when I presented the
What
check.
is your name?
I am Miss Madhumita Bayan.
You are also a lady.
A lady, my lord.
And the informant is also a lady.
No, no, he's a gents, my lord.
Ananda Kalita.
Ananda Kalita, my lord.
Okay.
Then I also lost the cross affair, my lord.
No, but it is alleged that at the time of taking financial assistance from her, she took my Innova Krista.
Yes. Yes, Innova Krista, part of the money was involved with the Innova Krista, my lord. Now, my lord, so far the payment is concerned, my lord, page 24, I have enclosed the bank account statement, my lord.
No, no. Thereafter, what was the allegation?
Lordship may see allegation, my lord, from last parameter. Now she has started, Lordship may see.
Yes.
Married, my lord.
Yes.
Now she has started harassing me over telephone. And on 23/5/2000, Srimati Madhuba Bayan came to my flat and gave a written demand letter amounting to rupees 87 lakhs to me through a secretary, Riskon Tower. She has also been sending kidnapping and death threats to me and my family for failing to pay the amount stated in the demand letter. These threats and insults are having a serious impact upon me and my family, and we have been living in constant fear. Therefore, I kindly this is now these checks, my lord. Some of the checks we have presented, my lord, is got dishonored, my lord. Now,
Who gave you check?
he gave me because he was to my lord
Against the loan.
against the loan, my lord.
Okay.
Now, my lord,
and the outstanding was 87 lakhs or not?
no, we have given 87 lakhs, my lord. We have given a letter to the secretary because he is not picking up the phone, my lord. So we approached his flat where, my lord, page, lordship may say page 65. Then we wrote to the secretary that he.
Okay.
If I have to kidnap, man, why should I go to the flat, man, to write to the secretary that he's at page 65, my lord, that is. Then lordship may see, page 24 onwards, my lord, I make the payment. Now, while registering the vehicle, my lord, I've got a special number, my lord. That special number belongs to, my lord, my son's and daughter's date of birth. That I've annexed the documents to that effect also. And 11,000 I transferred. Lordship may come to page 28, my lord.
Vehicle Which vehicle? This
Innova, Innova Krista, my lord.
This Innova was purchased in the name of?
Name of the Anand Kalita, my lord. Because he was so close to me, my lord, but being a family member.
But the petition, the informant is saying it to be my Innova, his own Innova.
Actually, Innova was purchased from the day one it was with me, my lord. Because I have even paid the special number that lordship may see page 28 for a moment, my lord. On the top, my lord, 23/4/21, Commissioner of Transport Kamrup, 11,000. This is a special number, my lord. And number wise, if your lordship sees the RC, my lord, RC book is at page 62. Page 62, my lord. Now, this RC book, the number is 2806, my lord. 2806, my lord. Date of birth of my son is 28/10/2010, my lord. So 28, I have taken the first number, and 06 is the date of birth of my daughter. So I got a special number by paying 11,000 rupees, my lord. Then, lordship, the insurance is done by my husband, my lord. That is also there, my lord. Insurance.
What is the dispute between you and the informant?
It's a money dispute, basically, my lord.
As regards the Innova or the loan amount?
He has taken the advantage of that situation, my lord. He is claiming Innova, and also there's a money dispute.
Innova is registered in the name of?
In his name, my lord.
In his name?
In his name.
So registered owner is the informant.
That will be decided, my lord, because I have to also prove that I have paid the installment and all that.
Now,
And
where is the Innova?
Innova, I have handed over to the police station, my lord. Lordship may see I have lost the cross FIR, which is at page, my lord, 67, my lord.
Now it is in police station.
Police station, I have handed over to the police station because he's.
From where you are saying that it is?
Yes, lordship may page turn to page 67, my lord. 68. 67 is my FIR stats, my lord. 68 is the. Therefore, I have bought the car before the dispute police station.
You have again lost an FIR.
Yes, yes. I also lost the FIR.
Why?
Because, my lord, he is alleging all false story, my lord.
Where is the statement regarding handing over of the Innova?
Yes, lordship may see page 68, second para, my lord. Therefore, second line, my lord. Therefore, I have bought the car before dispute police station for their custody. Otherwise, Ananda Kalita may again file a new case against me for keeping the car. So the disputed vehicle I have given to the police station, my lord. And now it's being, my lord, under rain and water.
Now, why are you apprehending?
Because my police also called me, my lord. I went to the commissioner of police.
You went to the police after filing of this FIR?
Yes, yes, I went to the police. My statement also recorded.
You were not arrested?
No, my lord. Para 10, my lord.
Then there is no apprehension.
No, police has advised me to take bail, my lord, because it's a non-bailable section, my lord. Otherwise, I would not have come, my lord.
No,
they are saying that
if police does not arrest you, where is the necessity of bail?
No, but at the advice of the police, I came before this court, my lord, because they said you take the bail because otherwise the non-bailable section, my lord. Because he is also making pressure on the police, because he went to the commissioner of police to register his FIR. The police has not registered the FIR. Lordship may see that I paid the installment from
but police is not trying to arrest you.
No.
Then there is no case.
No, lordship may see police has advised me to take bail, my lord. Otherwise, I would not have come to you. Because it's a question of money dispute, my lord. Because here, after all, he is the family member, my lord. We have helped him, and he subsequently, my lord, filed an FIR against us, my lord.
Yes, Ms. Das. Heard Mr. J. Roy, learned senior counsel assisted by
P. Shaha.
B. Saha, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor. This application has been filed by this application under section 438 of the Code of Criminal Procedure, Command 1973, has been filed by the petitioner, namely Mrs. Madhumita Bayan, who is apprehending her arrest in connection with Dispute PS case number 578/2024. Under section 420/406/385/387 of the Indian Penal Code. The gist of accusation in this case is that on 7/6/2024, one Sri Ananda Kolita had lodged an FIR before the officer in charge of Dispur Police Station against the present petitioner, alleging that the petitioner has taken the Innova Krista bearing registration number AS01 EU 2806, of which the informant is the registered owner. It is also stated in the FIR that the informant took a loan of amount of rupees 23,85,782 from the present petitioner. However, he had returned back an amount of rupees 54,43,708 to the petitioner, along with the interest. It is alleged in the it is also alleged in the FIR that even after liquidating the loan amount, the petitioner had illegally demanded an amount of rupees 10 lakhs as an interest from the informant, and had issued a demand notice seeking.
That is not demand, it is a information to secretary of the flat on association, my lord. He had alleged that it's a
Demand letter of rupees 87 lakhs to the secretary of Riscon Tower, where the informant resides. It is also alleged that the petitioner is threatening with kidnapping and death threat to him and his family members if he fails to pay the demanded amount money to her. Learned senior counsel for the petitioner has submitted that the allegations leveled in the FIR are not true. It is submitted that the informant was an acquaintance of the petitioner, and he used to regularly take financial assistance from the petitioner on several occasions. It is also submitted by learned senior counsel for the petitioner that the Innova Krista vehicle in question was purchased with the money of the present petitioner, and the registration number of the said vehicle was also allocated by the DTO on an application by the present petitioner after paying special fees for the same. However, as the said vehicle was registered in the name of first informant, it is first informant, on 10/6/2024, the petitioner went to Dispur police station and surrendered the vehicle before the Dispur police station. It is also submitted that on the said date, the petitioner had also lodged an FIR against the first informant Anando Kalita. Learned counsel for the petitioner has submitted that the petitioner there is a financial dispute between. No, Mr. Roy,
Yes, madam, financial issue.
financial dispute is there
Yes.
between the parties.
Yes,
You owe money or he owes money?
I want money from him. That I will prove it, but if I have a alternative course of action, I have to go to.
Learned
civil court.
senior counsel for the petitioner has also submitted that there is a financial dispute between the parties, which is of civil nature, and he is willing and ready to cooperate, and she is willing and ready to cooperate in the investigation. So, on the other hand, learned additional public prosecutor submits that perusal of the case diary would be necessary for consideration of the instant bail application, hence call for the same. In the meanwhile, considering the submissions made by learned senior counsels as discussed herein above, the petitioner, you appear before the IO,
yeah, look it.
the petitioner, the above named petitioner is directed to appear before the investigating officer of the dispute PS case number 578/2024 within a period of 10 days from the date of this order and cooperate in the investigation. Stop. If she does so within the stipulated period of time, in the event of her arrest in connection with dispute PS case number 578/2024, the above named petitioner shall be allowed to go on bail of rupees 30,000 with one surety of like amount, subject to following conditions. Condition number 1 and 2. Let this interim bail, let this case be listed again on 24. No,
That is after vacation.
after vacation. 25th July.
Obliged, madam.
May I please your lordship? Lordship, matter may be taken up after some time, lordship. I will consider Mr. H.K. decision leaves, lordship. You will apply that.
Okay.
Lordship. Deep lordship. I'm sorry, my lord, I was on port 1. Lord, this is a AB. The sections are 354, 354A, 506, 509, 27. The FIR is at my lord, handwritten FIR, not handwritten, my lord, typed FIR page 16. My lord, before coming to the content of the FIR, my lord, I have been served with, this is the third 41 notice, my lord. I have been served twice. I have appeared, my lord. And also,
You have
my lord,
appeared.
I have appeared twice, my lord, but this is the third, my lord, because my lord, there's a, now, please, FIR, my lord, please, the FIR.
What is the allegation?
Allegation is, my lord, that this person, my lord, the accused here, petitioner, my lord, and time and again tried to assault the informant physically. And also, my lord, one interesting, my lord, kindly finish the FIR, page 16. It is once
Petitioner, informant is a lady.
lady, my lord.
And
Once, my lord, again, my lord, this
what is your name?
My lord, my name is Sri Thisling Tuller. He's the Gambura, my lord. Maldi, the FIR at page 16, it's set as a set of facts, but it doesn't disclose any date. However, at page 17, there is a date. It's 25/2024. And my lord, the FIR is lodged at my lord, on the date, my lord, 18/6.
8-6, my lord, 8-6.
Allegations are,
But my lord, I had appeared twice. Page 6, my lord, paragraph 4. One I couldn't annex. Corollary to that, my lord, the
then,
annexure C.
then why are you apprehending?
My lord, this time what had happened, my lord? The paragraph 7, my lord, some women organizations have come, and my lord, they have went to the SP office. My lord, this time I have apprehension, my lord, that some coercive action may be taken, because my lord, this is the third time I have been called, my lord. Other two are summoned, I have appeared. This time situation is a bit different, my lord. That para 4, which goes on to para 7, my lord, states my urgency, my lord, the apprehension, the reason behind, my lord.
Yes, Ms. Das. Yes, let the CD come.
Well, may I pray for some interim, my lords? Vacation is also there, my lords. I have complied also. I have appeared page 20, my lords. Acknowledgement from the police. First, second notice I have appeared. Page
Where is
21.
the acknowledgement from police?
My lord, yes, my lord. This is acknowledged, my lord. It's signed by the IO at page 20.
Where is the case number?
My lords, in compliance to so and so, my lords. The case number is missing, my lord, but this is the notice, my lord. And same person, my lord, will see in page 21. Same signatory, my lord. Shankar Dutta, SI. Yet Naya ko case number. But same case, my lord.
He has appeared twice.
Twice, my lord. This is third notice.
Where is your apprehension? Para 4 and 5.
Para 4 and 5, my lord. Basically 4, my lords. And 5, my lord, if I'm arrested, my lords, this will be detrimental to my job also. I'm a Sarkari Gagura.
No, wait. And CD would be necessary. Sure, we are fixing a short date.
My lord.
We'll go through the statement of the victim. 27 or 28, whatever. 27.
27.
Heard Mr. D. Gogoi, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor. Considering the nature of allegations leveled against the petitioner in the FIR, perusal of the case diary is felt necessary for consideration of the instant anticipatory bail application. Hence, call for the case diary, fixing 27/6 for case diary.
The small objection, my lord will consider my interim on date.
The prayer for interim order shall be considered
20.
on the next day.
Oh, let me.
Item number 25.
Item number
May it please the lordship. Lordship, this is a commercial quantity. Lordship.
Admission of the orders of mention করেছিল যে। Okay, yes, yes.
Yeah. This is a commercial quantity, lordship. The contraband was seized 11 quintal 50 kgs.
How much?
11 quintal 50 kg.
11
quintal.
11 quintal.
Sorry, 1150 kg.
105 1150.
1150, lordship. So, ganja. Here,
When he was arrested.
two witnesses have been examined. The last witness was examined on 14th of December 2023. Until date, no development in the trial, lordship.
Was arrested on.
Yeah, arrested on
Oh, yes, he was arrested
17/12,
22.
22. So last more than 6 months, no development in the proceeding. And the two witnesses.
17, 12, 22. How much period has lapsed? Yes, Mr. Rahman, exactly how much period has lapsed?
This is five.
You calculate, Vivi.
5 months.
553.
No, in month. Or we will take it up after some time. You calculate the exact period.
Lordship.
You are on the prolonged incarceration or some other ground also.
For long incarceration, other grounds also, lordship.
Other grounds are also there.
Lordship.
Make submission to what other grounds?
First submission that I'm the first time offender. This is the first my ground. And
You have gone through that.
yeah, then later on I will take the grounds of undue delay. Lordship, I will refer the judgment of Muslim Hussain, Muhammad Muslim, and Rabi Prakash judgment.
No,
And-
first time offender, in the first offense itself, you have been involved in 1150 kgs.
Lordship. But no record has been available with the prosecution that I am the habitual offender.
No, but the first offense is itself, it is not a first, other factors may also be relevant. If a first offender consumes ganja or possess ganja of say small quantity, on this I need some assistance. First assistance.
Judgment that was placed yesterday, that was in that facts of the case.
Yes.
That charge
No,
was
I
late.
have some
not
more grounds also in this case. Yeah, I will pay.
What
So,
else?
The next is that the section 50 is not complied, lordship. Here, 4 accused are there in this case.
From
But-
where it was recovered?
The car, vehicle.
50 is not required for a car. Search of a vehicle,
Then-
section 50 is not required.
Then we can take the grounds of 52A also, lordship. Here I have the inventory also. That is 1150 kg also, or only written in the inventory. Nothing else. 60 packets wrapped with polythene packets, and total is 1150 kg. No separate calculation is there. So on this ground also I will place the record. The one more grounds I would like to take that section 309. In the special cases, 309 is required to be
No,
compliant.
therefore, yes.
Yes,
but
required to be compliant. which is-
Therefore, what is the period of detention is relevant, exact period of detention.
That we will
Yeah.
find out during the break, Lord, you can take
Right.
it up at two. No.
Or I can give you more time if you want to come prepared.
Lord.
Next week.
Not required. I will at 2 yet, Lord. I will do it at 2 only. Within 1 hour I can prepare myself.
Otherwise, 1.5 years is not that long incarceration. People have been inside for 2-3 years.
Yes.
Not-
Then in
not
that
only this-
case,
Not only this ground I would like to take, but other grounds also there, the mandatory provisions, then section 309 to comply, yeah. Yeah,
Mandatory, it is said, of course, it needs to be
Yeah.
followed.
but
No, how it has been violated that matter. Suppose there is no inventory. No,
inventory is there, Lordship.
in what manner it has been violated, that is mere assertion that 52A is violated.
Representative Central and all, I will have that.
Because in a, like he's submitting that first offender. All first offenders will not get benefit. It depends on the facts and circumstances, quantity of contraband seized. Mr. Rahman,
Lordship,
you come prepared with queries.
Lordship,
We are fixing it some other day.
Lordship, one Tuesday mechanically.
Okay.
Lordship wanted some assistance on that. That was the-
First, on the, in that case which you have cited
Lordship,
of Supreme Court, where Supreme Court said that first offender should get some leeway, some preference, or
Oh, and
some, then how it is to be interpreted? Under what circumstances first?
this is the, actually, this is this burden is on the prosecution side, because
No.
in general
You are relying on that judgment.
Lordship,
You have to assist this court by making your submissions that under these circumstances, first offender should be given advantage of.
I'll also find out few more judgments on that.
Yes.
Tuesday, Lordship will take it up.
Heard Mr. M. Rahman, learned counsel for the petitioner, as well as Ms. S. Jahan, learned additional public prosecutor. On request of learned counsel for the petitioner, let this matter be listed on 25/6/24.
obliged.
Yes.
Lordship, in this case, Ezahar lost on 2/9/2022. Petitioner also arrested on the same date.
What is the offense?
Lordship offense under 21B and 22C. Lordship, kindly have a look at the Ezahar page 12.
Page 12.
Lordship,
Yes. Yes.
may I read? With reference to the subject cited above, I have honored.
What was seized?
Seized, Lordship, 600 tablet, Yaba tablet, and 131 grams of heroin.
600 Yaba tablets
Lordship,
and 131 grams of heroin.
heroin. Lordship. Total number of tablet 600 and gross weight 66.
From
Yeah.
where it was seized?
Lordship, it is from the vehicle, one Bolero vehicle, Lordship.
No, what is your case?
Lordship, petitioner is in custody since the date of his arrest.
Prolonged detention.
Lordship. First. Second, Lordship,
How?
search was made at night.
What is the period?
Period more than 1.5 years, Lordship.
Exact what is it?
Exact, Lordship, 1 years, 9 months.
You have calculated properly?
Lordship, I think proper. It is on second to 9, Lordship. Slightly shorter than 9 months. 12 days, Lordship.
Okay.
Shorter than 9. So Lordship, search also made at night at 8:40 PM without any warrant, violative of section 42, Lordship.
How 42 was violated?
The Lordship, search was made at night, Lordship, without any warrant, Lordship.
Any other ground?
Lordship, prolonged detention.
Yes, Mr. Kaushik.
For the detention is concerned with the third frame only on 7/5/23. The FCR is up to date in 7/3/24. Till then, 3 witnesses were already examined.
How many witnesses are there?
Out of 10. Three.
Three.
Till 7/3/24. After that, I do.
How many witnesses are examined?
Lordship, so far my instruction from the 3 witness and out of 10.
No,
Lordship.
what was the last date?
Last date, Lordship.
We'll call for a status report, updated status. Updated status report. Heard Mr. L.R. Majumdar. Also heard Mr. R.R. Kaushik. On perusal of the scanned copy of the case record available with the case record, it appears available before this court, it appears that the same is updated up to 7/3/2024 only. And till then, 3 witnesses out of 10 listed witnesses were already examined. Learned Counsel, Learned Additional Public Prosecutor has submitted that in the meanwhile, perhaps more witnesses have been examined, and therefore an updated case status report of the, and therefore he praised that an updated status report of the case may be called for. In view of submissions made by Learned Counsel, Learned Additional Public Prosecutor, let an updated status report of the NDPS case number 130/2022 be called for from the Court of Learned Special Judge Karimganj. Special Judge Karimganj.
Lordship.
Special Judge Karimganj before the next date. List this case again on after vacation.
Lordship, before vacation,
Before vacation, will it arrive?
26 or 27. Lordship. 27 May.
Immediately after reopening of vacation. 16, 17, 17th of July. Let it be on 17th of July.
right.
Registry to take steps for requisitioning the updated status report from the trial court.
All right.
May I please, Your Lordship?
Yes.
I have filed a criminal revision petition. There is a 114 days delay due to some discrepancies regarding the website of the Learned Judicial Magistrate Court and the original report. Originally, I am a accused person of an NIAC case, and during the proceeding, the stage of
NIAC.
NIAC.
Then notice whether notice were issued on your condemnation delay petition. Notice has to go. We are issuing notice because here the respondent is a private respondent.
Private respondent.
This interlocutory application has been filed on filing of an application under Section 5 of the Limitation Act 1963 by the petitioner who has preferred the connected revision petition for condoning the delay of 142 days in filing the said revision petition, wherein he has impugned the order dated 30/10/2023 passed by Learned Judicial Magistrate First Class in CR case First Class where Kamrup Metro Guwahati in CR case number 2922 C/2018 issue notice to the respondent. The petitioner shall take steps for issuance of notice to the respondent by registered post with AD within 3 days from the date of this order, returnable on, give a fix. 22nd July. List accordingly.
Corona date fixed on 28, Lordship. Talco date was fixed on 28, but I have to reduce defense witness. Yeah, another IA also there for staying of the death.
Now, unless delays condone, no prayer.
Oblige,
No prayer. can-
Oblige, Your Honor. But maybe given some direction that I may be filed and petition that may be considered for the interest.
No,
of the
there
court.
is no bar in filing petition, but this court may not give such direction.
Oblige, Your Honor.
Item 26 and item number 56.
May I please, Your Lordship? Item number 26.
Item number 26 ಆಗುತ್ತೆ ma'am. Yes,
Yes.
26.
Before it, that one thing that I have done today, in the 11 witness level. But LCR is received on 28th of January 24. Since then.
No updated report is not there.
Okay, Lordship, on the last occasion also, no witness was examined. That was yesterday only, Your Lordship.
How many
20
witnesses have been examined
Not a single witness was examined, Your Lordship.
till now?
Yes, Your Lordship.
Certified copy of the order, all order sheets. Show it to Mr. Parashar. When were you arrested?
4/11/22. 1 year, 7 months, 17 days.
Last payment to 6/23. Last payment.
Yes, Mr. Parashar. Charges were framed on
2626.
what is your submission now?
My submission is long incarceration and Lordship, here also I was only in the vehicle, Lordship, and vehicle belongs to some other persons. And the articles were recovered from the dicky of the car, Lordship. I was not aware about that bag, Lordship. And if your Lordship see,
What was the recovery?
recovery is heroin, Lordship.
49 grams. Around almost half kg.
No, how many accused persons are there?
2. And in the charge sheet, it is
Both
said
of
that
them are behind the bars.
behind the bars. And 2 more
Since-
persons are there to be in the mentioned in the charge sheet to be as absconder.
And therefore it is not progressing.
No, against them it is already split up, but they are not appearing or.
Then why charges are not framed?
Charges are framed. Charges are
No.
framed.
Okay, then why for last 1 year, no witness has been examined?
They have not turned up.
But that's. Thing is that my lord,
Where do you stay?
Karimganj. Karimganj.
And the trial is going on in Karimganj.
Karimganj. Permanent resident of.
What is the assurance that you will face trial while remaining on?
Very stringent condition also, including government employee.
considering the quantity of the.
No, but
That is regarding that these.
Comparison to the-
Yes.
comparison
But regarding investigation part, it's almost
when the charge sheet was framed, charge sheet was laid,
Charge sheet was 28/4/22.
28/4/23.
22. Charge sheet submitted.
22 and charges were came on
2/6/23.
so since last 1 year, no witness has been examined.
And for framing of charge also, it took almost 1 year. I was in custody. Witness one.
Heard Mr. A. Ahmed. learned counsel for the petitioner, also Mr. K. Parashar, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, namely Ahmed Hussain, alias Ahmad Hussain, who has been detained behind the bars since 4/11/2022, within bracket, for last 1 year, 7 months and 17 days, in connection with NDPS case. What is the NDPS case number?
NDPS case 157/22.
Special case number 157/22, corresponding to the Patharkandi PS case number 262/2022. The gist of accusation in this case is that on 2/11/2022, one who is the first informant?
First informant is Hiteshwar Kolita, officer in charge of Patharkandi.
No, he received it is covered actually. Name of the first. On 2/11/2022, one Shri Dibakar Gogoi had lodged an FIR before the officer in charge of Patharkandi police station, inter alia, alleging that on receipt of an information through reliable sources that one white color vehicle bearing registration number AS01E9032 will be coming from Patharkandi towards Kathaltali, and same would be carrying huge quantity of suspected drugs, and a Naka checkpoint was put up at Sonakhira police check post, and the said vehicle was intercepted. In the said vehicle, from the said vehicle, Ahmed Hussain, within bracket, the present petitioner, and one Jamil Ahmed were apprehended, and during search of the vehicle, 37 numbers of various color soap boxes were recovered therefrom. Inside the soap boxes, suspected heroin was kept. On weighing of the heroin, it was found to be 497.99 grams. On receipt of the said FIR, Patharkandi PS case number 262/22 was registered and investigation was initiated. Ultimately, on completion of investigation, charge sheet was laid bearing charge sheet number 58 dated 28/4/2023, naming the present petitioner and one another co-accused.
Jamil Ahmed is also
Therein, Jamil Ahmed is also the petitioner.
Yes, in item number 56.
Okay, there we will naming the present petitioner and another co-accused as therein. Stop. learned counsel for the petitioner has submitted that though the petitioner was arrested on 4/11/2022 and he has already been detained behind the bars for last 1 year, 7 months
17 days.
and 17 days. However, till today, the charges are not yet framed.
Charges.
No, sorry. Till today, not even a single witness has been examined. It is also submitted by learned counsel for the petitioner that charges against the present petitioner were framed 1 year back, that is on 2/6/2023. And therefore, he has submitted that the petitioner, he has submitted that though the embargo of section 37 of the NDPS Act 1985 is mandatory in nature. However, in view of the long incarceration of the petitioner and inordinate delay in trial, the embargo of section 37 of the NDPS Act, 1985 is lifted and it gives way to the right of the accused protected under Article 21 of the Constitution of India. He has also submitted, learned counsel for the petitioner has also submitted that in spite of the fact that commercial quantity of contraband has been seized in this case, as the detention of the petitioner is long enough, his prolonged incarceration would override the embargo of section 37 of the NDPS Act. Thereafter, Amita, quote from bail application number 3881/2023. Quote para 8, 9, 10. Quote 8 and 9, don't quote 10. On the other hand, learned Mr. K.K. Parashar, learned additional public prosecutor, has vehemently opposed the grant of the bail to the present petitioner on the ground that sufficient incriminating materials against the present petitioner for possessing the commercial quantity of heroin is there in this case.
At least, shouldn't the conviction of Sujar witness and the IO.
He has also submitted that. Since huge quantity of heroin has been seized in this case, hence embargo of section 37 of the NDPS Act is applicable in the instant case, and he may not be allowed to go on bail, at least till the seizure witnesses and the investigating officer of the case are examined. I have considered the submissions made by learned counsel for both the sides and perused the materials available on record, including the scanned copy of the case record of special NDPS case number 157/2022, which was called for in connection with this case. it appears from available records that the petitioner was arrested along with the co-accused on 4/11/2022 and hence have already completed 1 year, 7 months and 17 days behind the bars. It also appears that though the charge sheet in this case was filed on 28/4/2022 and charges were framed on 22/6/2023. However, till now, not even a single witness has been examined by the prosecution side.
Charge sheet, my lord, 24/2023, not 22.
2020. Charge sheet is
The charge sheet is
28/4/2023, 3. Charge sheet date. Code para 17, 18, 19, 20, 21, 22, 23, 24. In the instant case also, the present petitioner has been detained behind the bars for more than 1 year, 7 months. And trial is and not even a single witness has been examined till now. Stop. Under such circumstances and in view of the observation of the apex court in the judgments discussed here, observation of the apex court in various ruling cited herein above, this court is of considered opinion that under the facts and circumstances of this case, the period of detention undergone by the present petitioner is long enough to outweigh the embargo of Section 37 of the NDPS Act 1985. And the petitioner is therefore entitled to get bail on the ground of prolonged incarceration only. Code para 26 with some changes. 1 lakh with 2 sureties. One of the surety would be a local surety from the state of Assam. And certain conditions, 6-7 conditions are there. 56 also same, similarly placed on same.
Same. Date of arrest same. They were arrested on the forwarding.
56 also same conditions. 56 same order. Only name will be changed. Petitioner's name will be changed. Charge sheet.
Charge sheet dated.
Same. Charge sheet number is same. Everything is same except the name of the petitioner.
Obliged.
Well, kindly pass over for the timing.
Okay. Passing over is at your own risk because we may not reach. Okay, call next. Bail. How long? What is the matter?
My lord,
What is the matter?
NDPS matter, my lord.
NDPS.
Yes, my lord. Section 20B, subsection 2, clause C and 29, my lord.
Investigation is going on. Investigation stage. Heard, Mr. What is your name?
A. Basumatari, my lord.
Heard, Mr. A. Basumatari, learned counsel for the petitioner, Also heard Mr. K. Parashar, learned additional public prosecutor, who prays for some more time for producing the case diary. The prayer is allowed. When? Let this case be listed again on after vacation.
Public one.
21/7/2000 and 22/7/2024.
Item 41.
Return city for FSL. Earlier city was there. FSL was not available because of the.
Now neither FSL nor CD is there. When will you produce? After vacation. Heard Miss, what? What is your name?
Dibangshari. I'll write it.
Heard Miss D. Bamshari, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor, who submits that the case diary which was available earlier was returned for updation, and the FSL report which was called are not available before this court, have not been received by him, and seeks some more time for producing the same. The prayer is allowed. Let this matter be listed again on 22 July.
Item 33.
Yes.
Yeah, please, Your Lordship. For 39 application, my lord, the petitioner is in jail for last 11 months. The last offenses under section,
What is the date of arrest?
my lord, date of arrest is 20 July 2023. 20th July, 11 months. My lord.
Offenses under section?
Under section 22C/29.
What are your grounds?
My lord, 1224 numbers of capsule, that is Ispascore 1 plus Tramadol capsule, were recovered by police from the possession of the co-accused, my lord, from the house and possession of the co-accused, my lord, that is Nozmul Haq. And on interrogation, Nozmul Haq disclosed that the said capsules he procured from the petitioner, my lord. And thereafter, the petitioner was arrested, my lord. In this regard, FIR, please have a look at page number, my lord.
No, this is a charge sheeted case.
My lord,
Trials already started promptly, my lord. In this case, charges were from on 18/1/24. 18/1/24. Since then, two witnesses already examined out of total 7.
Now, what is your grounds for?
Next date is
My lord.
25/6/24.
my lord, so far, two witnesses have been examined, my lord. They have been, please have a look at page number 19 and 24, my lord. 19 to 24.
No, what is your ground? Tell me on what ground you
My
are
lord,
seeking.
there is no whisper against me. Nothing has been recovered from my possession. Neither the seizure witnesses have deposed against me, nor any of the witnesses deposed against me regarding.
Then
bulk
why
of-
have you not challenged the framing of charges against you if there is nothing? When the charges were framed?
My lord, there was a prima facie case under as per section, as per the FIR, my lord.
If prima facie case is there,
There.
37 comes in.
My lord, the allegation is in the FIR only and nothing, nowhere else.
That is enough at this
My lord,
stage.
that the statement of co-accused, the 164 statement is not there. Only,
No.
please have a look at the statement of the co-accused, my lord.
Mr. Parashar. No, he is not on delay.
Hello?
You tell me the grounds.
My lord, my lord, the grounds is so far the statements of the witnesses, my lord, recorded under section 161. Nobody has made any allegation against me. Nobody, my lord.
So
Even
there,
even the complainant, the police officer, his statement is also there. Kesdar is there along with my learned friend. that
why
the
were you
copious-
arrested? Why was he arrested? If he's saying what I understand, that there is nothing against him.
My lord.
These two witnesses only examined till date.
No, you go through the record.
Evidence for
No, you go through, is there anything against him? If there is something against him, he will not get bail at this stage. If there is nothing against him, he's saying there is no material against him.
Yes, my lord, definitely. My lord.
Yes. Now, why charge sheet was filed against him? You also come prepared.
My lord, I am ready, my lord.
You does not seem to be ready
My lord,
because
my lord, I am ready. I have the 161 statement also along with me. Only, my lord, in FIR. Only in the FIR, my lord, the informant alleged that on recovery of the tablets from the co-accused told him that the articles.
so except the statement of the co-accused, there is nothing against you.
Nothing against me.
That is your submission.
That is my case.
So if there is nothing apart from the statement of the co-accused, then he may get benefit. You check the,
My lord, altogether 7 witnesses cited in the charge sheet, my lord. 2 of them Caesar witnesses, my lord. They have been examined before the learned trial court. They have deposed nothing against me. Even they have not
no,
supported
that will not help you. That will not help you. That will not help you. Other witnesses may.
Other witnesses, my lord, so far the 161 statement that those were supplied to me, my lord. So far I have gone through. Nowhere they have the said witnesses have.
Mr. Parag shall look into it. Let the PP go through. We'll take it up.
My
Today itself,
lord.
after some time. Yes, Mr. Uddin.
Yes, my lord. This petitioner is behind the bar since 3 years, 5 months, 28 days as on today, my lord. And my lord, this case was, my lord, lastly, it was fixed for argument, my lord. And at the stage of the argument, my lord, the prosecution filed a petition under section 311 CRPC for re-examination of PW5, my lord. SI1 Milan Manindra Bora, my lord. And accordingly, my lord, challenging this order of the learned court below, my lord, one co-accused preferred a criminal revision petition. And that is why this honorable court was also called for the criminal revision petition. My learned friend is appearing for this, my lord. But my lord, my case is that, my lord, due to my lord delay caused by the prosecution, this petitioner is, my lord, behind the bar since 3 years, more than 3 years now. And my lord, I have gone through the order. This petitioner has not taken any date, my lord. In every time, my lord, defense side, my lord, since 2023, defense side has taken the time. So, my lord, due to my lord long incursion, my lord, I pray bail for this petitioner, my lord. And regarding, my lord, this criminal petition, lordship, my learned friend will argue, my lord. And
The counsel for criminal petitioner is also there.
yes, my lord.
You're ready?
Yes.
We are concerned with this petition.
No, today,
Yes, ma'am. So,
Taking bail. For the trial is concerned, madam, that is almost, my other friend already stated that, madam, that is in the argument stage.
this is item number 34 and
34.
35.
Date of argument was none.
Then in the argument stage, then that means my trial is almost over. And his revision and petition filed by the them, it is caused by that revision petition. That is by the co-accused petition, who has filed this, revision petition.
Co-accused is also behind the bar.
no, my lord, he was granted bail by the learned trial court, my lord. And this, he earlier approached this
On
honorable court.
different ground, on,
My lord, he was granted bail, my lord, as per the order, no such material found against him, my lord. I have annexed the order, my lord. Lordship may kindly see order to the court. Bail injection order.
here it is, because here the witnesses are all examined.
No,
But prosecution side has again asked, again filed a petition for
Yes.
examining.
Yes, that I think that is not available in the case report. And we have the big day and one of the co-defendants filed the revision petition. Maybe the because of that, it has been stopped.
yes, my lord.
That's that issue, I don't have any idea because that, report is up to the, do that action. And so far, my lord, up to date, the record is concerned, my lord, and report 24, plus 64313 status.
Lordship may kindly see page 66. The order of the learned trial court, my lord, granting bail to the co-accused.
Page 66,
Yes, Lordship.
yes.
He was earlier approached this honorable court, my lord, and this honorable court was directed to approach the learned court below. And accordingly, he approached, and this order I have also annexed, my lord, page 64.
Yes, yes, make your submissions.
Lordship may kindly see the order. I have annexed the order sheet, my lord, from page 43 onwards, Lordship. Since the year, my lord, 2023.
What is the date of arrest?
My lord, he was arrested on 24/12/2020. I have annexed the forwarding letter also, my lord. Forwarding letter will find Lordship, page 16, my lord. Annexure 2, page 16 is the forwarding letter. Date 24/12/2022. 2% was arrested, my lord.
Now, how many accused are facing trial?
2 accused
Only two. One is on bail.
and another this petition.
You are behind the bars.
Yes, ma'am.
The bail order of the co-accused is at page
66. Page 66, my lord.
why he was released on bail?
My lord, it is stated that after perusal of the record, my lord,
Reasons are not properly mentioned in the order.
yes, my lord, I have typed one, my lord, page 66. The petitioner has submitted a copy of the order dated 29/6/2022 passed by the Honorable Guwahati High Court in bail application number so and so, wherein the Honorable Guwahati High Court was pleased to direct the learned court to consider the bail application on the basis of material on record and on its own merit. If a fresh application for bail is filed by the petitioner, peruse the order dated 29/6/2020 passed by the Honorable Guwahati High Court in bail application number so and so. By petition number so and so, the petitioner Desing Ronghang has filed
Okay.
this petition.
Yes, now I have understood your case. Oh, what is your submission?
My submission is just trial is so far.
So at this stage, even if there is a long delay, they are not entitled to get bail.
Because when a delay, they can take the leave of delay only if there is no likely to put. And here, evidently, the trial has going on in the last. And if it your lordship grants bail him at this stage, when it will affect the trial.
How?
My lord.
He may, might not-
Abscond, he may abscond.
Lordship may kindly see the order from page 43.
Come only that is to go, trial is not proceeding.
Lordship may kindly see page 43.
No, what is your reply to his submission that you may abscond if you are granted bail?
No, the Lordship may, my lord, stringent condition, my lord, for this, my lord.
Okay, heard, Mr. Jiuddin, learned counsel for the petitioner. Also heard Mr. R.R. Kaushik, learned additional public prosecutor. Let this case be listed for delivery of orders on 27, 28,
28.
28/6 for delivery of orders.
Obliged.
Item number 30.
Five will.
35 is for challenge this criminal petition. No, 35. No, both are different cases.
35 is. So it may be segregated, my lord.
Segregated, can it be fixed on different date?
Then he may get benefit. If you segregate it, then petitioner is.
So the issue is different in 35.
No, my lord. Issue is
No, the
directly
question
related
is,
to this. Yes.
because of 35, the trial is halted, stayed.
Captain Evans,
And because of stay, the delay is continuing, he will remain.
That 35.
If that, maybe, but if 35 is not disposed of, the detention would continue and trial will not progress. And he will, therefore 35 has to be disposed.
For 28, any day.
Before?
28.
Today it cannot be done. Wait,
It will
how much?
It will take some time
Time,
because I have
it
to
will-
place
okay.
everything to your lordship.
Okay. Wait,
Earlier case on 50, the revision petition record will also require.
Same record.
Same.
The records probably will be required. Case diary probably will, case diary probably will be required because my whole case is that lordship, in the application under section 311 filed by the learned PP, he did not mention anything. He simply said that PW file, it is required to re-examine the PW5 for the ends of justice, nothing more. And the learned session judge lordship, while passing the impugn order, observed that the learned PP verbally submitted that.
scan copy of the case record has not arrived.
No, in my case, it is not there, lordship. Case record, that application probably, though although I have submitted the certified copy of that application.
Okay. Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. R.R. Kaushik, learned additional public prosecutor. It appears from record that by order dated 15/11/2023. The scanned copy of case record of special NDPS case number 24/21 was called for from the Court of Learned Special Judge NDPS Hojai. However, same has not yet been received. Today, Learned Counsel for the petitioner has submitted that for consideration of the instant criminal revision petition, the scanned copy of the case record would be necessary. And in addition to that, the case diary of Bajari, which police station?
Doboka Police.
PS case. And the
Doboka
scan-
Police Station case number 448 of 2020.
And the scanned copy of Doboka PS case number 448/2020 would also be necessary. Hence, call for the same. Registry to issue fresh requisition for obtaining the scanned copy of the special NDPS case number 24/21 along with the scanned copy of the case diary of Doboka PS case number 448/2020 from the Court of Learned Special Judge Hojai. Let this case be listed date at the after. Let this case be listed again on 23rd of July.
Obliged. Can it be on 22nd also?
22nd of July.
Obliged.
ইটো এতিয়া একেলগে ৰাখিম পিছত separate কৰিম। Yes.
May it please Lordship.
Yes, Mr. Rahman.
Lordship, I have been languishing in jail for 692 days. That means 1 year, 10 months to 27 days. This can be not received. Received. In the court record, the last is
Scan copy.
flag B. Yeah, take one. Last time also. Last page of the court record. Take page of development. No development नहीं दिखवा रही है। ये अब देखो ना। Last date of the convocation.
Status report is there. Scan copy was not called for. Whether scan copy would be required.
Status report was called for.
Yes, next date is fixed on 2nd of July.
2nd July.
After that, some reasons are given.
The status report has received. LCR was not called in the second bail application, Lordship. And
Heard Mr. M. Rahman, learned counsel for the petitioner. Also heard Mr. R. R. Kaushik, learned additional public prosecutor. The status report received, status report of the NDPS case number 82/22, which was received from the Court of Learned Special Judge Karbi Anglong, shows the reasons for which the witnesses could not be examined on the date fixed by the court and the steps taken for ensuring the examination of witnesses on the next date. Considering it also appears that the next date of the special NDPS case number 63/22 is fixed on 2nd of July 2024 before the trial court, on which the witnesses have been summoned by the trial court for recording their evidence. On consideration of the status report furnished by learned special judge NDPS, this court deems it proper to list this case again after the next date fixed before the trial court and call for a fresh status report so as to know as to what happens on the next date fixed, that is 2nd July 2024. Stop. Therefore, list this case again on 23rd July. Let a updated status report as on 2nd July 2024 be called for so as to reach this court before the next date fixed from the learned special judge NDPS Karbi Anglong. Registry to take steps for requisitioning the status report as directed herein above. List accordingly.
POSCO, my lord. My lord, they were having an affair, my lord, but unfortunately.
376 DA 306 IPC, my lord, and 6 of POCSO Act.
But you have not taken steps.
My lord, I have taken already, I have received on 6/6/2024, my lord.
But on 18/6, there is an office note
That is.
that no steps.
As
As per office note, you go through the office note.
Yeah, I have gone through, but I have received, my lord, on 6/6/2024, my lord, I have already taken, I have
Where is-
received. On 6/6/2024.
Where is the acknowledgement receipt?
I have. It was submitted before the, my lord, registry also, my lord. In mobile, I have, my lord, original copy was submitted, my lord.
What is this?
Yeah, provided one acknowledgement.
Who has provided? What is this?
My lord, in mobile, I have received, my lord, but hard copy I was submitted before the, my lord, registry, my lord, on 6/6/2024, my lord.
No, how you got this?
My lord,
This one, from my office, it has come.
Yes.
So far, office note is concerned, it seems from the service it was taken. It was directed through registry. Maybe they have directly sent to IO.
This is from your office.
IO sent.
Heard, Mr. Heard, Mr. What is your name?
S.H. Sikdar, my lord.
S.H. Sikdar, learned counsel for the petitioner. Also heard Mr. R. R. Kaushik, learned additional public prosecutor. this application no. Learned it on perusal of the office note dated 18/6/2024, it appears that no steps for issuance of notice has been received by the registry as on 18/6/2024. However, learned additional public prosecutor has produced a photocopy of a document from where it appears that the notice issued to respondent number 2, Mohammed Anar Hussain, has been served by him by the officer in charge of which police station? Dhubri Police Station. Learned counsel for the petitioner has also submitted that Learned counsel for the petitioner has submitted that he has taken steps for
On 6/6
issuance of notice on respondent number 2 on 6/6
2024.
2012. We can deem proper service. No, whether fresh notices, fresh steps have to be taken, or we can deem it to be proper. No, I'm not on that. You have produced a document from which it appears that notice have been served. We can take it as deemed service on the, and will appoint an amicus. The notice on the respondent number 2 is deemed to be duly served. In view of the above, notice on respondent number 2 is deemed to be duly served. Any other amicus is present apart from Ms. Brown, who is in the list? What is to be done? No. Whether she is coming. It appears that though the notice has been duly served on respondent number 2, however, nobody has appeared before this court on behalf of respondent number 2. Therefore, this court deems it proper to appoint an amicus curiae to defend the cause of respondent number 2 / defend the cause of victim / informant in this case. And accordingly, Ms. Debashri Saikia, whose name is there in the list of amicus curiae prepared by this registry, is hereby appointed to defend the cause of the victim / informant in this case. The petitioner is directed to furnish a copy of the bail application along with the annexures to the newly appointed amicus curiae. Let this matter be listed again on 26, 6/24.
Published.
May it please, your Honor. 439 application, my lord.
Your lordship will find the FIR, my lord, at page 8, my lord. Small FIR, my lord. Two bikes were stolen, my lord.
CD is there.
In fact, my lord, on the last occasion when it came up before this court, my lord, I was asked to stay for some more days, my lord.
Your name is there in the FIR.
Yes, I have been in the FIR. My name is not there. If your
But
lordship
it
turns to
is seized from your possession.
No, my lord. Page 14, my lord. There's a CCTV footage, my lord. Page 14, my lord.
Oh,
Grounds of arrest, my lord. During investigation of the case, CCTV footage of the scene of crime was collected, which is found matched with the arrested accused person, Mohammed Saddam Hussein.
now what is your submission?
My submission is that, my lord, that CCTV footage is mismatched, my lord, because I am also having beard, my lord, and the photograph which has been shown in the CCTV is also having a beard. I am a, my lord, conductor in ASTC, my lord.
Okay. How many, when were you
My lord,
arrested?
I was arrested on, my lord, 28th last month, my lord, May, my lord. And considering the length of detention, my lord, today is around 25 days, my lord.
Apart from CCTV, anything else?
Only basis of CCTV footage he was arrested. Boy, unknown boy who asked him to accompany him for some work. They arrived at that place and after that was him to the statement. He is arrested. I reviewed the CCTV footage that is there.
No further progress of the investigation. No recovery of the vehicle. Anything else from apart from CCTV? Now, what is your submission?
But I was seen in the CCTV footage, but I was not carrying the bike, my lord.
He is also up to 29.5.
তোমার জমা হবে 27.
No, whether it is revealed from the case diary, under what circumstances he was seen carrying the bike.
Carrying bike that is not shown in that city. But on that location he was found.
Inside the campus.
Road.
He was found CCTV
Yes.
footage is of which place?
Huh? Outside the gate, my lord.
Because the allegation is that
I have narrated my case, my lord. If your lordship pleases, my lord, that your lordship will find at page 3, my lord, paragraph 6, my lord.
yes, Mr. Kaushik, what is your submission?
That is only this is the statement.
Now, what is to be done? Whether you require his detention or if he cooperates, it is
He is cooperating.
Okay.
The bike is not recovered.
okay. Heard Mr. N.J. Datta, learned counsel for the petitioner. Also heard Mr. R.R. Kaushik, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, namely Saddam Hussein, who has been detained behind the bars since 28/5/2024, within bracket for last 25 days in connection with Godsuk PS case number 155/2024 under section 447/379 of the Indian Penal Code. Learned, stop. The gist of accusation in this case is that on 27/5/2023, one Pritam Jyoti Barua had lodged an FIR before the officer in charge of Gorsuk Police Station, inter alia, alleging that that on 26/5/2024 night, on the night of 26/5/2024, two bikes were stolen from his residential campus by breaking the lock of the front gate. Stop. On receipt of the said FIR, Gorsuk PS case number 155/2024 was registered. It also appears from the forwarding report, which is available in the record, that the present petitioner was arrested on 28/5/2024. That is on the next day of the lodging of the FIR, on the basis of CCTV footage of the crime scene. Learned counsel for the petitioner has submitted that the petitioner is in no way involved in the offense alleged in the FIR and he is innocent. It is submitted that since the petitioner sports have a beard and the person who appeared in the CCTV footage also had a beard, he is suspected to be the person who appears in the CCTV. However, he submits that there is a mismatch between the person who appears in the CCTV footage and the petitioner, and he is not the person who appears in the said CCTV footage. Learned counsel for the petitioner has also submitted that the petitioner has already been detained behind the bars for last 25 days, and he is ready and willing to cooperate, and hence his custodial detention is no longer be necessary. On the other hand, learned additional public prosecutor has produced the case diary of Gorsuk PS case number 155/2024 and has submitted that petitioner has been arrested on the basis of CCTV footage of the crime scene where the person appearing in the footage matches with the present petitioner, where the image of the person appearing in the CCTV footage matches with the present petitioner. He has also submitted that till now the stolen bike has not yet been recovered. Witnesses examined. His statement is he has also stated that the statement of the petitioner has already been recorded by the investigating officer, wherein he had stated that the petitioner had come to the place with an unknown person and he is not involved in the offense alleged in the FIR. I have considered submissions made by learned counsel for the parties as well as peruse the materials available on record, including the case diary of Gorsuk PS case number 155/2024. Since the CCTV footage, which is one of the vital evidence, which may be one of the vital evidence in this case, has already been collected. And since the statement of the victim, statement of the present petitioner has also been recorded, and since the petitioner has already been detained behind the bars for last 25 days, and no breakthrough has yet could be achieved for recovering the stolen bike, this court is of considered opinion that further custodial detention of the present petitioner may not be necessary if he cooperates in the investigation. Stop. In view of above, the petitioner, namely Saddam Hussein, is hereby allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate, Kamrup Metro, with following conditions. Condition number 1 and 2. With above observation, this bail application is hereby disposed of. Send back the case diary.
I'm deeply obliged.
My
Rashid.
lord, may I please, my lord? This is bail application 1690 under section 439. My lord,
But charge sheet
petitioner is.
has been,
admitted.
you appear before the trial court and pray before.
But my lord, in Caesar list, whichever
Charge
is
sheet submitted against whom? Against the present petitioner. That is.
7 equals there, no? এখানে তো এগুলো হয় না, Caesar is তো
You appear before the trial court.
My lord, whatever is sealed, both the mobile handsets are belongs to him only.
No, we
And
don't,
whatever is mentioned in the affair, it is not
we
recovered
don't
from
know
the
against whom charge sheet has been submitted.
on suspicion only he is arrested, my lord.
No, in view, you heard Miss, what is your name?
J. Datta.
J. Datta, learned counsel for the petitioner. Also heard Mr. R. Kaushik, learned additional public prosecutor, who submits that though the case diary was called for in connection with this case, however, in the meanwhile, the investigating officer has laid the charge sheet bearing charge sheet number
342/24. My lord, any protection, any direction, my lord.
No, you are already behind the bar. This is not anticipatory bail application. What was the last line?
48
Bearing
days.
charge sheet number so and so. In view of the fact of laying of charge sheet, this bail application is disposed of with an observation that the petitioner may approach the trial court and may pray for bail before the such said court, if so advised. You pray before bail before the trial court.
I left.
Item 42.
May I please, your lordship? 439 application, lordship. CD was called for in this case. Monday, because one point we have raised in this case.
What point?
One point regarding this lordship, 23 ground, 23 point something recovered with the containers lordship. If that excluded, it may come to the.
Wednesday, let it be on
Can it
Monday.
be on, can be on Monday, lordship, if possible, lordship.
Monday, not possible.
Monday in the second half, if possible, time permits.
Again, Monday it will be difficult.
Diary is there, lordship. They informed that is well.
CD is there.
Lordship, just now received.
Let it be on Tuesday. Tuesday. Monday, we have lot of cases.
If lordship intermediate quantity, then they have crossed 112 days, lordship. That is why, lordship.
This matter came up two, 3 days ago also.
Day before yesterday, lordship.
Okay. Heard Ms. S.K. Nargis, learned counsel for the petitioner. Also heard Mr. R.R. Kaushik, learned additional public prosecutor, who submits that though the case diary is reported to have arrived the office of the public prosecutor, however, it is not before with him now, and he seeks some time to go through the same and place the same before this court. Considering the submissions made by learned counsel, let this case be listed again on 24/6/2020.
Deeply, your lordship.
Item 60 from supplementary list.
Notice person, right? My lord, here, my lord.
The, yes, Miss.
My lord, with all respect, my lord, the section of law attributed, my lord, 8, my lord, 7 is the penal section, 8 is the punishment, 3 years and maximum 5 years, my lord. Whether
Here also something submitted.
Charge sheet submitted.
Mana can I place it in this manner, my lord, with regulation, notice by the madam.
You are appearing for informant. What is your submission? Charge sheet has been submitted against the present petitioner.
Time should be expedited. What, 4:38, 9 about this.
Trial should be what?
Short period.
No, this is a 439 petition.
My lord.
You are behind the bar.
My lord, my lord.
And in the meanwhile, charge sheet has been laid.
Late. My lord,
Then
one
the
of-
trial court is the best court to decide
Can I,
whether
can I
to.
please, of course, my lord, I should I or should I not, when a POSCO matter, my lord, similar thing happened, my lord, when, my lord, this is the order, my lord, can I please, if possible, 5
No,
years.
no, what should be the proper approach? When during investigation,
Both the procedures are followed, my lord.
That ganja were recovered from a train compartment, lordship, the way the petitioner was sitting from the under the seat, it was recovered, lordship. The petitioner were 2/7/2022, lordship. And as of date, it is 709 days. As of date, till today, 709 days, they are in the custody. And on 7/12/2022, the charge sheet was submitted. And charge was framed on 7/12/2022.
charges were framed on,
On 7/12/2022.
and charge sheet was laid on.
Charge sheet was laid on. Sorry, lordship, charge sheet was laid on 7/12/2022, lordship. Sorry, lordship, charge was framed on 7/12/2022, lordship.
Charge sheet. Let it come up on Tuesday. You come prepared.
No, lordship, only that, lordship, charge sheet I could not annex, lordship. That only thing is that on 31/5/2023, two PWs were examined, lordship. And till then, lordship, till today, lordship, no PWs have turned up, lordship. There were altogether
Mr. Kaushik, you have anything to say?
6 PWs, lordship.
I thought, so far the report available. That is not up to date, but till that time, 2 cases were examined. Out of 5.
But till 18/6, he says that
No.
And 2 cases were examined out of 5.
And that was on the 31/5/2023, lordship. That I have annexed in the petition, lordship, the both the witnesses.
when charges were framed,
Charge was framed on 7/12/2022.
anything?
Otherwise, they were ready.
But it was kept that I'm not to that point, lordship, that regarding the long incursion, lordship, that the 709 and considering the age of the ladies, lordship,
One is 55 years and another one is 58 years old lady, Lordship. Now by this time, Lordship, they are 60 years, 60 year and the other one is 57. Lordship.
Heard Mr. S. Munir, learned counsel for the petitioner. Also heard Mr. R. Kaushik, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioners, namely Ramila Bibi, who is 55 years old woman, as well as and number 2, Laila Bibi, who is a 58-year woman, who are detained behind the bars since 2/7/2022, within bracket, for last more than 1 year, 9 months, in connection with compute the time. What is the time?
1 year, 9 months, Lordship, 9 months, it will be
More
16
than-
days.
More than 1 year, 9 months.
709.
In connection with NDPS case number 214/2022 under section 20B2C/29 of the NDPS Act, 1985, pending before the Court of London, additional session judge number 2, Kamrup Metro. Where is the affair?
FIR on page 12, Lordship.
The list of accusation in this case is that on 1/7/2022, one B Doimari, ASI of police, had lodged an FIR before the officer in charge of Guwahati GRPS, inter alia, alleging that on that day at about 9:30 p.m. while conducting routine train checking duty in the train number 15909 Awadh Assam Express at Kamakhya railway station, seven packets of suspected ganja wrapped in a black color polythene was recovered from the lower berth of the train, which was occupied by 3 ladies. Namely, what happened to third lady?
She is still, Lordship.
Namely Ramila Bibi, Samija Bibi and Laila Bibi. Ramila Bibi, Likhibo, petitioner number 1. Samija Bibi and Laila Bibi, petitioner number 2. On weighing the recovered ganja, it was found that the said ganja weighed 27.4000 kgs. On receipt of the said FIR, Guwahati GRPS case number 86/2022 was registered and investigation was initiated. Ultimately, where is the charge sheet? On completion of the charge sheet.
Lordship,
Charge sheet is not there.
not with the petition.
Ultimately, on completion of the investigation, charge sheet was laid against the above named petitioner and one another co-accused, and NDPS case number 214/2022 was registered. It is submitted by learned counsel for the petitioner that though the petitioners are detained behind the bars since last more than 1 year, 9 months, And though the charges were framed against both of them on 7/12/2022, however, till now, only 2 out of the 5 listed witnesses have been examined, and there is no hope of culmination of the trial at the earliest. It is submitted by learned counsel for the petitioner that the last date fixed in the trial of the NDPS case number 214/22 was 18/6/2024. And on the said date also, no witnesses turned up. And the next date of the case is fixed on 2/7/2024 for evidence. Learned counsel for the petitioner has also submitted that though the embargo of section 37 of the NDPS Act, 1985 is mandatory in nature, however, considering the inordinate delay in trial as well as prolonged incarceration of the above named petitioners, the embargo under such circumstances is lifted and it gives way to the right of the accused under Article 21 of the Constitution of India. Quote from bail application 1881/24, quote para 8, 9, 10. On the other hand, Mr. R. Kaushik Namit, additional public prosecutor, has opposed the grant of bail to the present petitioners on the ground that the quantity of contraband seized from the possession of the above named petitioners is of commercial quantity, and therefore the embargo of section 37 of the NDPS Act is applicable in the instant case. And hence they may not be allowed to go on bail. It is also submitted by learned additional public prosecutor that already 2 out of 5 listed witnesses have been examined and only 3 witnesses remains to be examined, which would not take much time for completion of the trial. I have considered the submissions made by learned counsel for both the sides and have perused the materials available on record, including the case diary of NDPS case number 214/2022, which was called for in connection with this case. Code para 17, 18, 19, 20, 21, 22, 23, 24, 25 with some changes, and 26. From where these women belong to? Where this?
Lordship, West Bengal, Lordship.
Will they appear?
Still that condition will be given, Lord.
They are allowed to go on bail of rupees 50,000 each with two sureties of like amount. One of the surety should be the permanent resident of this within the state of Assam with certain conditions. Condition number 1 to 6. With above observation, this bail application is hereby disposed of.
Lordship, I'm sorry, Lordship, one motion item was there, Lordship, supplemental time being, Lordship, only CD, Lordship, that, next week, Lordship, the item 57, Lordship.
57.
Only CD, Lordship, next week, 379 case, Lordship, only arrested because of, earlier previous record. Lordship.
Item number 57, heard Mr. S. Munir, who's heard Mr. R. Kaushik. Call for the case diary, fix.
It's from Gorsuk, Lordship, can it be 26 or 27?
Fix
Already 35 days.
Fix 27.
26, Lordship.
27.
Lordship.
For case.
Much obliged. Much obliged, your Lordship.
Have you gone through, found something?
Statement of the petitioner is available that he has business relation with the Nodrul, from which house that the government seized, and now he has not continued his business relation because of that he has. But why at the point of spraying of salt is not, I don't know. Might have.
But there is no material.
From the statement of the Nodrul, he has stated that
No, that may not be ground for. So why he was detained behind the bars for the last 11 months?
Shasita also mentioned Shasita had trademark number because of the statement of the Nodrul on where. But exactly what Nodrul has said, that statement is not. Why in the CDS can scan copy, but statement of Nodrul is not available. Statement of the petitioner I have found. Statement of the petitioner I have found. It is mentioned that as per the statement of Nodrul, and which is already reflected in the FIR also, as per the statement of the Nodrul, that he has been arrested and already succeeded. But what is the exact statement of Nodrul?
Which was the case?
Malab.
Do you have any authority? Case laws?
Yes.
Where Supreme Court said
Malab.
that?
Malab.
Which was the case?
Malab. My Lord, I have relied upon the decision of the Honorable Apex Court, Supreme Court, that is Bharat Chaudhary.
Bharat Chaudhary does not help you. How it helps you?
My Lord, in this case, my Lord, Tufan Singh's case has been discussed, my Lord.
Tufan Singh help you?
Tufan Singh's case has been discussed, my Lord. And based on Tufan Singh's decision, Bharat Chaudhary case has been decided, my Lord.
No, so you should rely on Tufan Singh only.
Tufan Singh, my Lord. Tufan Singh, my Lord.
Where is Tufan Singh?
In paragraph 5, my Lord, of the said judgment, my Lord, on Bharat Chaudhary, my Lord, the paragraph of Tufan Singh that has been mentioned, my Lord. Paragraph 5, my Lord. Being by
Yes, Mr. Parashar, anything?
paragraph 5.
Tufan Singh.
It will come in the trial of the trial only till now.
The confessional statement.
You go through Tufan Singh. Bring Tufan Singh's case.
That apart, my lord, I am relying upon the decision of this.
One thing that in the scan copy, the statement of Nazrul, taking your brief this topic, that statement is not.
My lord, I have.
Basing of that, on the basis of that statement of the co-accused, suspect, his name is here, he has been suspected. But that is not.
But even if it is available,
Now,
apart from the statement of co-accused, is there anything else?
the whole city came on not follow this number. And not, this statement must be there in the case there.
I have enclosed, my lord, the statement of Nazrul, co-accused, my lord, along with my petition.
You have annexed
Yes, my lord.
at page?
Yes, my lord. Yes, my lord, 29, 29, my lord.
Read what he says.
My lord, statement of accused Nazmul Haq, son of Abul Qasim, village Moriam Nagar, PSM district, Golpara, Assam, recorded under section 161 CRPC. My name and address as mentioned above is true. My age is about 38 years. I eat this tablet for long ago and sometime sale also. I took these tablets from one Bodiur Zaman of Moilapathar. I have to say this much. Bodiur Zaman is myself, is a petitioner, my lord. This must be evidence, statement.
No, after getting this information, and I did not collected any other material.
Nothing.
Because the case there is there, this statement also not available in the case. This statement that might be.
Copy has been supplied to me, my lord, under section 20 CRPC, 207 CRPC. Copy to us. No, I have already.
Heard, Mr. What is your name?
J. Hussain.
J. Hussain, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor.
My master is executive speaker 25/6.
25/6.
25/6 next. And very frequently, the examination are going on.
Lord, I am in bar for last 11 months.
No, but if there is nothing against him,
My lord, there is nothing, my lord. I am in 11 months for last
the
11.
case law which you are relying, you should give that case law to Tufan Singh.
I have already submitted three judgments, my lord.
3 judgments are, you are relying on Tufan Singh.
Tufan Singh, my lord, Tufan Singh has been discussed in the said case, my lord. In Bharat Chaudhary, my lord. Paragraph number 5, my lord.
No, it is, the entire case is not discussed. You produce Tufan Singh.
Particularly, my lord, so far section 67 NDPS Act, the confessional statement of co-accused is not admissible. That was discussed in Tufan Singh's case, my lord. That part has been incorporated in this judgment, my lord, Bharat Chaudhary case. That about, my lord, I have relied upon his decision of our Honorable High Court, my lord. Let's see, our Honorable High Court also decided. I have submitted this judgment, my lord, in Rameshwar Kakoti and others, my lord. In paragraph number 52, my lord, that observation has also been made by our Honorable High Court, Division Bench, my lord. That the statement, confessional statement made before police without, unless and until recorded under section 164 is not admissible. So, my lord, the Nazrul Haq stated that he procured the tablets from me. That confessional statement was not recorded by the IO under section 164, my lord, before the learned magistrate. So, my lord, I am in jail, my lord, for last 11, my lord, or only two witnesses, two witnesses have been examined, those with the Caesar witnesses, my lord. They are,
Oh, I have to go through this scanned copy. Heard Mr. J.
J. Hussain. J. Hussain.
Hussain, learned counsel for the petitioner. Also heard Mr. A.K. Parashar. List this matter for delivery of orders on Wednesday,
My lord,
26. On
26,
26,
my lord.
I'll pass orders on that.
Item 59. Deliver to the.
And in the meanwhile, you,
Tufan Singh, sir.
Tufan Singh's judgment, you give it to me. Today itself.
Today itself, my lord. Okay, my lord.
Citation is available with you.
I'm extremely sorry. I just failed to appear in the morning hours.
Yes. Item number?
59. Come on. Lord, in fact, a similar against the, my lord, same FIR, two persons approached this honorable court. Your lordship was pleased to protect those persons. There were 7 accused persons, my lord. Out of them, 2 got call from police, and accordingly they approached this honorable court. That Vihan Kunet matter, your lordship will remember. So after protection of this honorable court to those 2 persons, my lord, police are like now calling the other persons. So that's how, my lord, this 5 persons are before your lordship.
Where is the FIR?
FIR.
Now this application is for how many petitioners?
Present one is for 5 petitioners, my lord.
They had agreement with different
Exactly.
different informants.
Exactly. Your lordship will kindly come to the FIR. Your lordship will find page 36 and relevant portion wherein the accused and informants are there. That your lordship will find page 37. Serial number 1, Masar Bora, MS. She is connected to Hina Ahmed, my lord. Hina Ahmed entered into an agreement with Masar Bora. Then Nilutpal Gohai entered into agreement with Nippon Bosumatari. 3 and 4, your lordships has already protected. Chayanika Kashyap is in agreement with Fakhruddin Ali. And
Sonia Rabha.
Sonia Rabha, she is not connected to anyone, my lord. Her name has been falsely implicated. And last one is connected to.
What is the name?
My lord, I'm just giving the name, my lord. I'll just check the type copy. Its name is Santanu Chakraborty, my lord. Santanu Chakraborty is connected to Mridul Das, my lord. Serial number 3 in the informant side.
Rest contentions remain same.
Race contentions remain same, my lord.
On that day, Mr. Parashar was not there.
Mr. Gogoi was there on the.
Same relief they would get.
Same day allowed to dispute.
Heard Mr. H.K. Das, learned counsel for the petitioners, and also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the has been filed by 5 numbers of petitioners, namely 1, 2, 3, 4, 5. Yar Prasad. namely 1, 2, 3, 4, 5, who are apprehending their arrest in connection with this could be case number 538/2024 under section 406/420 of the Indian Penal Code. Next quote from AB case number 1592/2024 1592 pura para 3 quote koribe. Quote para 3. Where is the FIR?
FIR, my lord, you find page 36, my lord. Type copy is at page.
Learned counsel for the petitioner has submitted that
26.
that the above named petitioners were the independent distributors of Vihan Direct Selling India Private Limited and had entered into an agreement with the informant stop. It is submitted by learned counsel for the petitioner that the informant Nipon Basumatari, that the petitioner Masan Bora had entered into an agreement with Hina Ahmed, the petitioner Nilottal Gogoi had entered into an agreement with Nipon Basumatari.
Yes.
The petitioner Sainika Kashyap had entered into an agreement with Fakhruddin what?
Alimal.
Fakhruddin
Ali.
Ali. And the petitioner Samtanu Chakravarti had entered into an agreement with informant Mridul Das.
Yes.
It is also submitted by learned counsel for the petitioner that the petitioner Sonia Rabha's name has been falsely implicated in the FIR. It is submitted that the agreements entered into between the petitioners and the informant were regarding engagement in the business of selling of various products and services, the details and price of which were available in the website through the independent distributors who were authorized by the company within bracket Vihan Direct Selling Private Limited for promoting, marketing and selling the products directly or by way of multi-level marketing. Code para 5. Code para 6. Code para 7. Code para 8. This code para 8 and 9. This case is fixed on 19/7 along with the earlier case, and you are allowed to go on interim bail of 30,000 each.
Much of it. Deeply. obliged.
43.
Lordship, my apologies on last occasion when this matter was taken, now we are not present, Lordship.
Up to date CD. You are on interim bail.
Yes, Lordship.
How, Mr. What is your name?
NZ Chaudhary.
NZ
Chaudhary.
Chaudhary. Learned counsel for the petitioner also heard Mr. R. Kaushik, learned additional public prosecutor, who submits that though the case diary is available before the court, however, same is not updated, and an updated case diary would be required for consideration of the instant bail application. Hence, prays for some more time for producing an updated case diary. The prayer is allowed. Let this case be listed again on 25/7. The interim protection granted to the petitioner shall continue till next day.
Much obliged.
The case diary be returned back and called back again after updation. After? Hmm? None appears for the petitioner on call today. It appears on perusal of the case record that on last occasion also, that is on 23/20/24, when this case was called for, no one had represented the petitioner. Stop. It appears that the petitioner is no longer interested in pursuing this anticipatory bail application. Hence, this anticipatory bail application is dismissed for non-prosecution.
As per my information, Lordship, charge sheet was submitted, Lordship. So,
Charge sheet submitted.
as per my information, but I have not the number, Lordship. So, Lordship, it may be, Lordship, disposed of.
You take information of on before the heard Mr. What is your name?
AK Azad, Lordship.
Heard Mr. A.K. Azad, learned counsel for the petitioner. Also heard Mr. R. Kaushik, who submits that case diary has not been received. On the other hand, learned counsel for the petitioner submits that he has the information that in this case charge sheet has already been laid. On this, learned additional public prosecutor sought some time for seeking information regarding the fact of laying of charge sheet. The prayer is allowed. Let this case be listed again on 27. 27/6 for 27/6. Stop.
There is a
The
interim order, Lordship.
interim order shall continue till next day.
Post number.
Item 46.
My pleasure, Your Lordship. Also, port 38 application, Your Lordship, it's a charge sheeted case, Your Lordship.
438.
Lordship. FIR is page number 9, Your Lordship. Vernacular is page number 12, Your Lordship.
No,
LCI receipt,
why
Your Lordship.
438 you are seeking?
LCI receipt, Your Lordship. And after service of notice, Your Lordship, private. MIQ.
Why haven't you not appeared before the trial court?
Lordship, earlier rejected my anticipated bail, Your Lordship, at page number 15 by the learned court below, Your Lordship, session court. Annexure C. After filing of charge sheet, Your Lordship.
Now, what is your ground?
Sir, kindly peruse the 164 statement of the victim, Your Lordship.
Where, at which page?
164 available in the LCR, Your Lordship.
Have you received the summons?
No, Lordship.
You have not received summons?
No.
Then you will
But
receive.
after charge sheet, Your Lordship, my bill prayer was rejected, Your Lordship. Page number 15, Your Lordship.
Anticipatory bail prayer was rejected.
Lordship.
Or charge sheet has not.
But it is mentioned in the order, Your Lordship, page number 15, Annexure C of my petition, Your Lordship.
Page number?
15, Annexure C.
No, page number?
Page number 15, Annexure C of my petition.
Last page.
Last page.
However, CS is not formally received by the court.
Lordship, paragraph number 3.
So charge sheet has not been submitted.
First submitted, available in the record, Your Lordship.
No, where charge sheet has to be submitted? It has to be submitted before the appropriate court. Now, suppose if you were
But
detained,
only technical issue, Your Lordship, my bill press was rejected, Your Lordship, not formally submitted. Charge sheet is not formally received by this court from the IO, Your Lordship. In view of the above circumstances, I am of the view that it is
okay,
not
let us
the case
assume
where the
that it is
pre-release
still
should be
pending
granted.
under
After going through the case study, it appears that IO has already completed the investigation. Has submitted strategy against the accused petitioner residue showing that whether petitioner as per the, however, CS is not formally received by the court from the IO. Because strategy is the.
charge sheet is not submitted. It is ready for submission. Ready for submission. Yes.
And on the view, Your
Now,
Lordship,
what is your
my
case?
bill pro was rejected, Your Lordship. My case, Your Lordship, kindly be peruse the 164 statement, Your Lordship,
Now, where is the 164?
at LCR, Your Lordship. Actually, informally 164 statement not supplied to us, Your Lordship. In LCR, it is
No,
circulated,
question of supplying now does not arise.
Lordship.
The charge sheet is yet to be. Where is the 164 on which you are
164.
relying?
At LCR, that may be available on the record, Your Lordship.
Yes.
Kindly peruse and consider my bill prior, Your Lordship. There
Okay,
is
I have
nothing
perused.
force, Your Lordship.
I have gone through. You make your submission. What is your submission?
As per 164, Your Lordship, there is no any force, Your Lordship. She come willfully, Your Lordship, and she is over 17, Your Lordship, and there.
May I please, Your Lordship?
I'm on interim, my lord,
Lord Mr. J. Mr. Bhuya. Item number?
47, man.
Heard Mr. J. I. Bod Bhuya, learned counsel for the petitioner. Also heard Mr. R. R. Kaushik, learned additional public prosecutor, who submits that the case diary has not been received by him and seeks some time for producing the case diary. The prayer is allowed. Let this case be listed again on 23rd July. The interim protection shall continue till next date.
My lord, this is 438 bail application, my lord. Here, my lord, the FIR lordship will see at page, my lord. At page 16 is the operative part of the FIR, my lord. It was registered under section 12 of POSCO Act, my lord. Punishment is only for 3 years, my lord. May I read?
Yes. What modification want do you?
Lordship, the bail order is annexed in page number 18. Lordship, you see. Page number 18, clause number 4.
Oh, yes. What is the confusion?
Lordship, the ID cards, Aadhaar card, driving license are separated by commas. The petitioner here does not have his any driving license, PAN card, such documents. He only has his Aadhaar card. And because these names are separated by commas, the trial court has interpreted that all the ID cards are necessary.
So Lordship,
When the bail order was passed?
it has been 2 months, Lordship. It was on
Okay.
20th of April.
This heard Miss N. Sultana, learned counsel for anything. Also heard Miss M. Deka, learned counsel for the NCB. This interlocutory application has been filed by the petitioner Suraj Singh for modification of the condition of bail order dated 24/2024, passed in bail application number 586/2024 by this court. It is submitted by learned counsel for the petitioner that the above named petitioner was allowed to go on bail by this court by order dated
24,
24
2024.
2024, passed in bail application number 586/2024 with certain conditions. And condition number 4 attached to the said bail application read as follows. Condition number 4, Didibo, that the petitioner, within inverted comma, that the petitioner shall provide their contact detail, including photocopies of Aadhaar card, driving license, PAN card, mobile number, and other contact details for the trial court, before the trial court. Inverted comma close. Learned counsel for the petitioner has submitted that as in the aforesaid condition, the words Aadhaar card, driving license, PAN card, and mobile number are separated only by commas. The learned trial court interpreted that all the aforesaid documents shall be required to be produced by the petitioner at the time of submitting his bail bond. Whereas learned counsel submits that the petitioner possess only only the Aadhaar card, and he does not possess any driving license and PAN card, and therefore if the said conditions are, and therefore the said condition has, and therefore he could not produce the said document even after lapse of 2 months of passing of the bail order in his favor. Stop. It appears that under the facts and circumstances of this case, the condition, if the condition is interpreted as requirement of all the photocopies mentioned in the condition number 6, then it would be too cumbersome for the petitioner, as he possesses only Aadhaar card and not the other documents. Under such circumstances, the condition number 4 attached to the bail order passed in favor of the above named petitioner on 24/2024 in bail application number 586/2024 is modified as follows. Number 4, within inverted comma. Now listen, the petitioner shall provide the petitioner, what is the name?
Suraj Singh.
Suraj Singh shall provide his contact details, including the photocopies of his Aadhaar card, or driving license or PAN card and mobile number, you have mobile number and mobile number, comma, and any other contact details before the trial code. Inverted comma close. The learned trial court shall
Any contact number then.
read the condition number 4 in the bail order of the above named petitioner as modified today, as modified by this order herein before. Is it okay?
Mobile number of his family member, because he is inside the jail for about 4.5 years.
Mobile number,
Of his family member.
mobile number where he may be contacted. Mobile number where he may be contacted. Anybody's mobile number where he may be. With above observation, this interlocutory application is hereby disposed of.
Deeply compliance notes. My lordship, I like to mention to allow my item number 54 for 27 June, my lordship, as matter is very urgent, my lordship. Item number 54.
Item number
54, my lordship.
54.
54.
50.
Daily
Due
list.
to paucity of time, it may not be taken up. List this matter on 27 June. Other matters, if it is not important, it will be left over.
Urgent,
Which matter?
attempt with 23 left. Obliged, my lordship.
Obliged.
Humble prayer for listing it on Monday, my lord, 24.
Monday we are very tight. Monday kiman case আছে sir? This is in admission column.
Admission, ma'am.
Item number,
23.
you are for
And for the petitioner, I'm
For
LSC, my lord. But
that
my name is
success.
not reflected in the court list. I'm S. Nidhi.
on Monday, it will be difficult.
Yes,
Any other day,
and Tuesday.
because Monday same scenario will be there. Even if it is listed. Putul. Wednesday. On Wednesday.
May it please your lordship, I beg to mention item number 51. This matter will be taken up on Tuesday.
What is 51? Okay, 51 on Tuesday.
May I please, your lordship? Your lordship, I beg to mention item number 22 of today's list. Your lordship may kindly take up the matter on Tuesday, your lordship.
52,
22. your lordship.
22. Admission method,
Yes, your lordship.
suspension of sentence.
No, your lordship, it is for quashing of the NI Act case.
Then let it come up
Your
after.
lordship, but there is no stay and the case is fixed on 28/6 in the trial court, before the learned trial court.
But NI Act matters.
Your lordship, we have already made the payment and in fact, in their affidavit in opposition, they have admitted that we have made the payment.
Then why it is pending?
Why? Because it has not reached the matter today.
No, you compromise the matter. Is
Uh,
there any,
No, your lordship, we have paid.
but he's not admitting.
He has filed the case subsequently. They have issued the notice.
So there is a dispute.
No, but in their affidavit in opposition, which they have filed before this honorable court, they have admitted.
Because last week would be motion week. There will be lot of cases. Let it come up after
Lordship, then my
Immediately after,
stay, then I
After-
may be granted stay. also.
now,
in
now
there-
nothing can be done. After vacation at that day. 16/7. I'm giving a fixed date.
Some protection may be given, your lord.
The
Otherwise-
protection is that you are given a fixed date. Other. 16/7.
Much of
Item number 52, my lord, is the interim order.
Interim shall continue in 52.
Vacation. Vacation.
No, after vacation. Let it be on 27. 28. 28. Retain CD till then.
May I please? Regarding item number 24, my lord, there is suspension of sentence, my lord, application is there. But any convenient day, my lord, in the next week, my lord, maybe.
Next week, we don't have convenient dates.
Lordship,
Your submission is for convenient date, but we don't have any convenient date on.
Lordship, any day, 27 or
Let
28,
it be of after reopening,
my lord.
immediately after reopening.
My lord, he's a, my lord, teacher.
What is the offense?
Offense, my lord, 376, my lord, conviction.
Let it be after reopening.
My lord,
Give a day. I'm giving a fixed date.
Lordship, may I pray for, my lord, 28, my lord. We'll try, my lord, maybe reached or may not be reached, my lord.
Okay, then 28.
28.
28.
Oblige me. Much.